all of you colleagues after a brief break. Let me welcome all of you members on the virtual platform on this day, the 14th of April. Welcome the invited evidence leaders to this committee, Advocate Bauer and Mayosi. Welcome all of you members of the media, our entire support staff in your various duties, members of the public who probably would have had time in the break to go through the documents. I'm sure you yourself would have started analyzing the work that we do. I want to welcome you in your different platforms, 408 and YouTube. We're resuming our meeting just to indicate, I think for today, we're continuing where we left as the committee meeting, and perhaps later on when we adjourn, we'll indicate how far we are to the inquiry, to the resumption of the inquiry. And so I don't want to waste time now to go there. I'm going to ask Advocate Bauer perhaps to just remind us and recap us and tell us where we are now in the unpacking of the evidence that would have been placed in front of us over those 6 days, because that's what we want to conclude and complete in the remaining time before the resumption of the inquiry. Advocate Bauer.
Chair, good morning to the members and the public. Chair, I took the committee largely, or we took the committee largely through a substantial part of the record in the CR17 Busasa matter. I then took the committee, we dealt with the issue of the references in the affidavits insofar as it related to the IGI report, and I indicated that I would come back to the issue of the judgment as there was something missing in what I needed to check. But for today's purposes, I will come back to that at some point. For today's purposes, I'm going to look at what is contained in the judgment with reference to the reports which are referred to in the PP SARS unit report. We'll call it the SARS unit or the Godan report. And we do so with reference to the affidavits that was filed with the PP prior to the litigation, what was filed and served at court, and what was said in the judgment about it, so that one understands the judgment in the context of that. What I don't look at for this purposes is the argument that prevailed in it before the court, but I will take you to essentially the legal argument in respect of, in particular, intelligence services in the judgment, to get an understanding of that in the context of the affidavits. And I do so not because I am buying into this notion that the judgment isn't binding. The judgments are binding, and that and I say this as a preface so that you can understand where I'm coming from, but this is to give the committee an understanding of the affidavit evidence which is serving before the committee in the context of the judgment. So as a starting point, there must be an understanding, and I'm not making a closing argument. I just want to put the affidavits into context, that the High Court had ruled that the existence of the unit was lawful, and that finding stands. So to the issue of whether Minister Godan had played a role in establishing the unit is of little moment in the light of the finding by the High Court that that was lawful. I'm simply doing a trolling through the evidence to give you an understanding of that. And so when I start with that, I'm going to start with saying is that what the judgment finds in paragraph 88, and I'm just going to read it. We don't need to go there for the moment. Is that in determining whether the public protector's findings were rational, it was therefore important to ascertain what process she followed in coming to the findings and what evidence was available to her when she made her findings. The reports on evidence is then discussed in the judgment. And that's important because it's a particular point in time that the court looks at what is before it and what was put before. They're saying this was before the public protector. And she obviously on affidavit tells the court her version of it, and we will deal with that. Right? So if we turn to the first thing, which will deal with the Sikhakhane report and Nugent Commission report. And I'm also going to preface by saying this, in some cases, there are quotes taken from the report that are repeated in the affidavit. So to not repeat quotes to the committee, I will simply indicate those as we go along and not read those out to you. And I want to start with Shepo, you must open up bundle E, right? The committee can follow as we go along. So don't open up, go to bundle E, and it will be the first one of the record. Be bundle volume 10. Bundle E number 7, and it will be volume 4, number 4. And I'm going to try where I can to give you the PDF number so that you can find it easily. All right, where we can do that for the most part. I've tried to do that. So if you go to PDF 387. So before the report is issued, Mr. Pillay provides the public protector with 2 affidavits. And this is the first of those 2 affidavits that we're going to go through. Maybe just go to the top of it so that the committee can see which affidavit we're in. To the top, just so that we go down. So there's a complaint, and Mr. Pillay makes this complaint to do that. And I'm not going to read the entire thing to you, but if we start and you can follow as I take you through it, just hold on a second, and we start at paragraph 6. At the time this affidavit is made, and he tells you this later in the affidavit, he had already left the employ of SARS in May 2015. And although there's a subpoena asking him to provide records, information, etc., he's not in possession of this. And he says that later in the affidavit. All right, but if we start with paragraph 6, right, he identifies that that there are 12 allegations which are wide-ranging, and it's clear that notwithstanding the vagueness with which the allegations are cast, that not only do they cover a lengthy period of time, but also they refer to events that in the main occurred between 10 and 20 years ago. Right? He then says in paragraph 7 that he was effectively provided with 6 business days between the 10th of April and the 23rd of April to respond thereto. And then he goes in paragraph 8. He complains of a lack of a fair administrative process, and in particular, the inadequacy of it, because in this matter, there seem to have been allegations by Mr. Shavambo, but there's also an anonymous complaint which is not revealed. And in paragraph 8.3, he specifically states that paragraph 3 of the subpoena threatens me with criminal sanction should I fail to comply with the demands made in the subpoena. And paragraph 4 says He says, I shall deal later in this affidavit with the fact that the number of the allegations now made were previously considered by the Public Protector almost 5 years ago. And then if we move on, just go to paragraph 13. He makes the point that he's not in the employ of SARS and he doesn't have access to records, information and witnesses. And then he says in paragraph 14 that under chapter 6 of the Tax Administration Act, he has limitations in respect of the disclosure of confidential information in relation to SARS to any party not in the employ of SARS. He then goes on. He points out that his attorneys had requested the cooperation in paragraph 14, that his attorneys had requested the cooperation of SARS in providing documentation to assist him to respond to the subpoena following a meeting with SARS officials, but that they had declined to provide the information, indicating that they pertain to personal information of third parties and internal operations of SARS. So at the time he answers this, he doesn't have documentation since that would be in the possession of SARS. He further makes the point in paragraph 16 that at this stage he has been charged with the commission of certain alleged offences, which charges remain pending against him. And although they are unfounded and vexatious, they hang over his head, and he does not waive effectively his rights under section 35 of the Constitution to do that. So he stands by those rights, and it's against that background that he answers the affidavit. In paragraph 19, 22, he points out that effectively that in August 2014, when he was acting commissioner of SARS, the Public Protector addressed correspondence to SARS in which he stated, and this is Advocate Madinsela, in which he stated that a complaint had been made to our office that SARS had established an allegedly surreptitious investigative unit known as the National Research Group to conduct clandestine specialized investigations against unsuspecting civilians, politicians, and prominent businessmen for possible tax evasion. The Public Protector informed SARS that she had elected not to investigate these allegations and set out her reasons for making that decision. So effectively, there had been a decision by the Public Protector not to investigate them. Further, that inasmuch as such allegations suggested unlawful or illegal activity on the part of SARS or its officials, this was and remains denied by me. Further, he says that the Public Protector went on to inform SARS that the investigation would in the circumstances be limited to issues relating to allegations concerning irregular recruitment processes in the appointment of the National Research Group officials and two other issues which are presently irrelevant. The Public Protector sought pertinent details and responses from SARS regarding the alleged irregularities in the appointment of the National Research Group employees, and SARS, when Pillay was still the acting commissioner, delivered a detailed response, including supporting documents to the Public Protector, which dealt with those requests. So then, if you go to the, I'm not going to go into further details on this affidavit. He then deals with certain answers. There's then a subpoena issued against him, and he, it starts at page 21, PDF 383. Go to that. All right. And he then files an affidavit in respect of this subpoena. Right. And I'm going to deal with the averments in the affidavit that deal with essentially the Sikhakhane panel report and the other reports. So go to paragraph 31.7 of this affidavit. It's not a, yep. Here we go. And he says the Sikhakhane panel report is fatally flawed in fact and law. And he then points out the documentation in which it was as such recorded in. He says, first he starts with his my submissions to the Sikhakhane panel in August and September 2014. My submissions in December 2014, which I prepared after the Sikhakhane panel had been delivered, which I addressed to the then SARS Commissioner, Mr. Tom Moyane. A legal opinion obtained by SARS in January 2007, sorry. A legal opinion obtained by the then National Intelligence Agency in 2007. A legal opinion obtained by SARS in May 2007. A legal opinion obtained by the then SARS Commissioner, Mr. Moyane, in September 2015. A legal opinion obtained by Mr. Praveen Gordhan in March 2016. Right. Then he says, testimony deposed to under oath by retired Judge Frank Cruan, who had chaired the SARS advisory board before the Commission of Inquiry into Tax Administration and Governance, that's the Nugent Commission, in September 2018. In this regard, I drew attention to the main report of the Commission delivered in December 2018, where the following was recorded by Judge Nugent in regard to that testimony. SARS advisory report chaired by Judge Cruan, quoting it, reported to the Minister and issued a media statement saying the unit was unlawful, but in evidence he told the Commission that was not a conclusion reached independently by the board, but had been adopted from the Sikhakhane panel, and he had come to realize it was wrong. Indeed, he supported the re-establishment of capacity to investigate the illicit trades, which we recommended. And then the final report of the Commission, where the following was stated by Judge Nugent. Why such a unit was considered unlawful is not clear to me. While the National Strategic Intelligence Act prohibits the covert gathering of certain intelligence that applies to intelligence concerning threats to the safety of the state. So Judge Nugent says the Act prohibits the covert gathering of certain intelligence that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax. The members of the unit might at times have acted unlawfully, that SARS employment policies might have been breached, that members might unlawfully have acquired and used equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish and operate a unit to gather intelligence on the illicit trades, even covertly within limits. Indeed, that was the view expressed to SARS in late 2015, which seems not to have been made public by SARS. An opinion was furnished to the former Commission of SARS on or about 1 September 2015 in response to the findings of the panel chaired by Advocate Sikhakhane, by Advocate Trengove, and Advocate Nkmalo. And it was said to be unlawful by a panel chaired by Advocate Sikhakhane, but I find nothing in its report to persuade me that it was so. Advocate Sikhakhane was asked if he could elaborate, but his reply took it no further than what was said in the report. And so I want to digress for a moment to take you to the Nugent report in a little bit more detail so that there's some understanding of what the Nugent report was about and what it said. And if we go to bundle E, 7, item 4, it would be PDF, it could be in the same document, go to 706. Yeah, right. There are 2 reports by Judge Nugent. One is the interim report dated 27 September, and then a final report that he comes out with at 11 December 2018. And the gist of the first report was an advice effectively saying you need to appoint a new commissioner of SARS. But in the course of that, he deals with this issue in a few paragraphs from 35 onwards, right? And I'm going to come to the status of this commission before we deal with the final report, but let me just deal with what's in the interim report first. In paragraph 35, he says, an account of what brought SARS to its present condition must start with the extraordinary consequences of reports in the Sunday Times that an unlawful rogue unit existed within SARS. The unit concerned was a unit that had come into existence in about 2008 under the name Special Operations to investigate the illicit trade in tobacco, liquor, counterfeit goods, and so on. It later changed its name to the National Research Group and again metamorphosed into the High Risk Intelligence Unit, which comprised 6 members. Go down. Going to paragraph 40. I have not yet found why the creation and existence of the unit was said to have been unlawful, which is how it was consistently and uncritically depicted. I find no reason why the establishment and existence of the unit was indeed unlawful, and I'm supported in that by an opinion given to Mr. Moyane by leading senior counsel in late 2015. As far as I'm aware, that opinion has never been publicly disclosed. It might be that some of the activities of one or more of its 6 members was unlawful, but that is something else. If that was indeed the case, it is nonetheless incredible that unlawful acts of one or more of 6 men led to millions of rands being spent and the holding of repeated inquiries with continuing damage to the reputation of SARS. What sparked this off was a report in the Sunday Times on 12 October 2014, some 2 weeks after Mr. Moyane took office on 27 September 2014. It was reported that an unlawful rogue unit existed within SARS whose members had planted listening devices in the home of former President Zuma. That report and others that follow in similar vein was to do immeasurable damage to SARS and to the lives of many people. Mr. Adrian Lakay, who was then the spokesperson for SARS, had got wind of the allegation shortly before the report was published, through questions that were being posed to him by journalists, and he urged Mr. Moyane to take steps to deal with the allegations. But Mr. Moyane ignored him, contending that the allegations would come to naught, in stark contrast to his conduct when the allegations were published. Once having read the report in the Sunday Times on 12 October 2014, Mr. Moyane called together the members of EXCO that afternoon and demanded to know what they knew about the allegations, and all the members disavowed any knowledge. On Monday, the members of EXCO were summoned once again, on this occasion with their subordinates, and were asked once again what they knew. And the members of EXCO once again disavowed any knowledge, whereupon Mr. Moyane promptly announced he had no confidence in the members of EXCO and that it was disbanded. That response is extraordinary in any rational terms. Mr. Moyane had barely arrived at SARS with no experience of revenue collection, yet almost immediately he denounced and humiliated senior management with vast knowledge and experience and dissolved the body through which SARS was being managed. All that on the basis of no more than a newspaper report, and moreover a report on events of which at least most of the chief officers could not be expected to have had any knowledge. Go to paragraph 43. Meanwhile, in October 2014, Mr. Moyane ordered the disbandment of the high-risk investigation unit and the termination of surveillance of those who were under investigation by the unit. Now, new capacity was created to continue its functions. It can be inferred from analytical evidence we have heard that there is at present a material of ongoing loss of revenue from tobacco-related taxes for want of investigation and vastly diminished regulation of the illicit economy. Paragraph 44. December 2014 was a busy month for Mr. Moyane. Following on the decision to do so in October 2014, a consulting firm called KPMG was appointed by Mr. Moyane to investigate the rogue unit allegations, particularly so far as they might implicate Mr. Pillay, Mr. Richer, and 2 others at an ultimate cost to the taxpayer of about 24 million rand. The money was subsequently refunded. I think that's what it says. Has since been returned to SARS. Computers were seized and a mountain of correspondence and other documents were trawled through until a preliminary report was prepared in about June 2015, making damning allegations against Mr. Pillay. In particular, consequent upon which criminal proceedings were initiated against him and others by Mr. Moyane. That was to be followed by criminal charges being brought against Mr. Pillay, Mr. Magashula, and Mr. Gordhan in circumstances still unclear to me, which were later withdrawn. He then issues a final report. Seppo, if you go to the bookmark, it would be the very next report. I think it's PDF 796. The other paragraphs in the interim report does not relate specifically to the SARS unit, which is why I'm not going there. Maybe just go to the top of the report, first paragraph. Okay, there we go. No. Now it's got to be the top of the report. So go to you in chapter 6. Go down. Okay, then go back to the bookmark. Right, go down. It's PG-13, I think. PG-14. Click on PG-14. Right. Now, I want to take you to the beginning of it so that you understand what is the difference between the Nugent Commission and the Sikhakhane report. Go down. Go to the paragraph 1 on the first page. Right. So the former Minister of Finance, Mr. Gigaba, first decided a commission of inquiry should be established in connection with SARS, gave evidence before the commission, right? And he said that he had formed the view that an inquiry was required because the integrity of SARS was being questioned domestically and abroad. He concluded that a process was needed to look into the affairs of SARS, from which recommendations could emerge addressing issues of governance and integrity that were of concern to investors, the rating agencies, the international finance institutions, and the tax-paying public. Right. So they were then the commission was then the what commonly became known as the Nugent Commission. There were terms of reference. Go down. Right. Down. Right. And he then provided this report. If you see it, paragraph 6, he then says there are many elements to good governance. Principally, in any organization, it is the oversight role of senior management structures that are able to put a brake on abuse of authority. But senior management was driven out or marginalized at SARS, and we have seen no evidence that senior management appointed by Mr. Moyane was anything but compliant. In a tax collection agency, oversight at every step in the tax collecting process is also vital. But the development of its sophisticated information technology, which has inbuilt checks, was summarily stopped, and the organizational structure of SARS that provided oversight was pulled apart. Dissent was stamped out by instilling distrust and fear. Accountability to other state authorities was defied. Capacity for investigating corruption was disabled. On the eve of his suspension, Mr. Moyane was about to dismantle governance over the settlement of major tax disputes. To report on each question posed by the extensive terms of reference in isolation would trivialize what had happened at SARS. I have reported instead in broader terms on what happened at SARS over the period under inquiry. Within that will be found as many answers to the questions posed by the terms of reference as we have found. But when integrity and governance has failed, as happened at SARS, it has probably manifested itself in many ways that are yet to be found. The hallmark of good governance in an institution is the existence of a culture of healthy dissent. Mr. Moyane substituted instead a culture of fear and intimidation. What is most needed and what is being looked at for employees at SARS is an end to its present debilitating uncertainty through a new commissioner with integrity and managerial capacity to restore that culture of healthy dissent. And it's against that background that this commission looked at matters. Go to paragraph 27. And there's a context that's coming to this detail, but I want to detail the interaction that Mr. Luther Lebello had with the Nugent Commission, because his affidavit is one of the his affidavit before the Nugent Commission is one of the documents that had been provided to the evidence leaders by the Public Protector's Office, as being one of the documents to which regard was had. Members will recall that this issue was raised during the evidence that was being led with Mr. Mataboge. Mr. Luther Lebello, Group Executive for Employee Relations at SARS, approached the Commission on more than one occasion, and I afforded him considerable time. He asked to give evidence, and it was agreed that he could do so. He said too that he wanted to furnish documents to the Commission in support of his evidence, and in due course he delivered documents in 5 lever arch files to the officers of the Commission. It turned out that the documents had been compiled by a Mr. Mafakela. Go down. As it turned out, what Mr. Lebello wanted was a platform to ventilate what he says was wrongdoing on the part of Mr. Pillay, Mr. Richa, and Mr. van Lochenberg, which I come to presently on the pretext of demonstrating that there were grounds for disciplinary steps that were taken against them. Mr. Lebello duly gave evidence twice at public hearings. Interspersed with that, he submitted an affidavit. The common thread through all he said before and submitted to the Commission was his wish to demonstrate that there was evidence that the persons I have mentioned were guilty of the wrongdoing he alleged. At the outset of his oral evidence, he said that by giving evidence, he would be compelled to continue to do what I hated for the last 4 years, which is to keep on saying these things I'm going to say today, which does not only hurt the integrity of the people that we are talking about, but it hurts also their families and their futures. He felt compelled to do so, he said, because the alternative was that the stigma of being a suspension hit and a purger will continue for the rest of my life. Fortunately, we were able to spare Mr. Lebello the pain of hurting those people once again and of hurting their families. It was not necessary to take up the time of the Commission by reading out aloud what he contended was proof of wrongdoing on the part of the persons concerned, which is what Mr. Lebello had in mind doing. Mr. Lebello was told on more than one occasion that we accept that counsel who drafted the charge sheets against him would not have drafted charges had he not believed on the material placed before him at the time that there was a case to meet, which was the ostensible purpose of reading the documents aloud. Whether the cases brought against him would have been met is not the concern of this Commission. There are forums for putting people on trial, and the Commission is not one of them. Moreover, clearing Mr. Lebello of the stigma of being a suspension hit and a purger is not the purpose of this inquiry. Mr. Lebello considers he bears such a stigma. It is best he approaches those whom he considers to have attached that stigma and clears it up with them. That notwithstanding, Mr. Lebello persisted in response to an invitation from the Commission to furnish submissions on why certain findings affecting him should not be made. He forwarded to the Commission an affidavit of some 135 pages, excluding its voluminous annexures, almost of all which was devoted to airing yet again what he claimed to be proof of wrongdoing on the part of Mr. Pillay, Mr. Richa, and Mr. van Lochenberg, which he appears to have disseminated to a section of the media. He complained as well that an affidavit he had earlier submitted to the Commission had not been placed on the Commission's website. Certainly, his affidavits and his documents have not been placed on the website of the Commission, nor will they be. The website of the Commission was established to facilitate access to evidence that is material to its findings. It is not a medium for disseminating whatever might be dumped at its door. If Mr. Lebello wants to disseminate his material, which is not confidential, he is perfectly free to do so, but the Commission will not disseminate it for him. The Commission does not accept whatever might be foisted upon it. It had invited anyone to place evidence before it and has considered everything that has been submitted, but that does not mean everything placed before it is material evidence. It accepts what is material to the inquiry, which Mr. Lebello's documents and affidavits are in large part not, as he was told so many times, and it is for the Commission, not Mr. Lebello, to determine what is material. So far as his affidavits contain relevant material, the relevant parts have been considered and taken account of, but the Commission will not be party to disseminating what is no more than malice. I might add that Mr. Lebello is not the only one who has sought to use the inquiry. as a platform to advance his or her own cause. Others have also walked into the offices of the Commission with their documents or imposed them on the Commission electronically on various subjects they want disseminated to the world, and their material has been treated just the same. I need also add that earlier in the inquiry, Mr. Van Lochenberg submitted a lengthy affidavit dealing with and exonerating himself of the allegations that had been made against him. In the same way, Mr. Van Lochenberg was told the allegations are not material to the inquiry, and he quite properly did not persist. There is a related matter I ought to dispose of briefly. Mr. Lebello's documents were gathered together by Mr. Mafakela, whose firm had represented SARS in the disciplinary proceedings, apparently at a charge to SARS of about R1 million, later reduced to about 750,000. 100,000. It appears from his invoice that much of his time had been taken up with attempting to link the contents of the documents to alleged transgressions of the persons concerned. In due course, Mr. Mafakela wrote to Mr. Lebello on 22 August 2018 and sent a copy to me. I am not quite sure why, purporting to prove from extracts from the documents the alleged transgressions. Mr. Mafakela also said that SARS must be given a platform to provide its version of events around 2014, particularly as to what led to the initiation of disciplinary proceedings against Mr. Pillay, including his suspension. He said his suspicion that the Commission had decided to avoid the allegation was based on the ongoing lobbying to bring Mr. Pillay back into SARS. Mr. Mafakela was also invited to furnish submissions on why certain findings should not be made concerning his instructions, particularly on what authority he purported to speak for SARS, and he too responded with an affidavit. Amongst other things, he said the Commission is not authorized by its terms of reference to make such findings, which is not correct. Nonetheless, it appears from his affidavit that the acting commissioner had already taken the matter up, and no doubt he will also consider whether Mr. Lebello's conduct is befitting a senior employee of SARS, in which case no findings or recommendations are required. Go down. The acting commissioner rightly renounced the letter as not representing the views of SARS. We have been told that Mr. Lebello's delegated authority to dismiss employees has also been removed. We are gratified by both. It is time that dignity and decency return to SARS. Paragraphs 41. We have become acutely aware as the inquiry has progressed that the Commission has been sought to be drawn into an onslaught upon those who managed SARS before Mr. Moyane arrived, founded upon allegations once peddled by the Sunday Times to a beguiled public for a year and more about a rogue unit that was alleged to have existed within SARS, which is what Mr. Lebello's documents were all about. An inkling that that was in store appeared soon after the Commission was established, and it became increasingly apparent as the inquiry progressed. The Sunday Times withdrew its allegations and apologized some 2 years later. But meanwhile, a vast amount of taxpayers' money was splurged by SARS to trawl through documents going as far back as 11 years in search of evidence of wrongdoing. The allegations were fueled by leakages of information, and lest the public should be minded to forget, the allegations have been opportunistically repeated even in an official SARS media release I come to later in this report. When revenue collection is compromised, the consequence of one or more of three. Government programs must be curtailed, taxes must be raised, or money must be borrowed, all of which prejudices the country. That is what this Commission is about, and it will not be diverted from inquiring into what is wrong at SARS and how it can be righted by attempts to use it for other ends. If there was wrongdoing on the part of those who manage SARS before the period with which we are concerned, then the proper course is for it to be reported to the authorities. The Sunday Times did great damage to SARS and the people of South Africa, and the Commission will not now pick up where it left off. And then I want to go to page 796 of the report, where it picks up the issue of the alleged rogue SARS unit again. There. The most senior employees of SARS are the commissioners and its chief officers who report directly to the Commission. And then it points out immediately before Mr. Muyani took office, there was Mr. Ivan Pillay, who was an acting commission. The committee will know that there was the complaint in respect of two issues. One was his pension payout before the public protector, and the other one, which is linked to the SARS report related to his qualifications. The second one was Mr. Barry Hall, the Chief Officer Operations, and we had seen from the complaints that had been raised that he's implicated in the complaints which had not yet been investigated by the public protector by the time this report that we're dealing with has come out. Mr. Kwesi Low, the Chief Officer Legal and Policy, Mr. Jean Ravel, Chief Officer Tax and Customs Enforcement, Ms. Elizabeth Kumalo, Chief Officer Human Relations, Mr. Bob Head, Acting Chief Officer Finance, Mr. Peter Richer, Acting Chief Official Strategy, Enablement and Communication. Right? Go down. Then he repeats the two paragraphs that I had read to you earlier from the interim report. So go further down. Paragraph 4 is also a repeat about the meeting that Mr. Muyani has with his exco and his disbanding. Paragraph 5(2). Wait, hold on. He makes an inference at the bottom. I read you the part that all about him disbanding and asking the chief officers, and he said that the chief officers could not be expected to have knowledge. And then Judge Nugent draws the conclusion. The inference is inescapable that this was the first step in neutralizing possible detractors as foreshadowed in Bain's TM 100 Days presentation. In short, Mr. Ho resigned, Mr. Pillay and Mr. Richer was suspended and later resigned. Mr. Ravel resigned. Why that occurred is, so far as Mr. Pillay and Mr. Richer is concerned, requires some explanation or requires explanation. Then he comes to the so-called rogue unit. The unit concerned was the successor to a unit that had been established in about 2008 to counter the illicit trades in commodities such as liquor, cigarettes, and counterfeit goods. It started in about 2007 when a proposal was considered for funding staff within the National Intelligence Agency to address organized crime and the illicit economy. Mr. Pillay was then General Manager Enforcement. Mr. Pillay and Mr. Kodan, who was Commissioner of SARS, addressed a memorandum to the Minister of Finance requesting approval to fund a special capability within NIA to supply SARS and law enforcement with the necessary information to address the illicit economy. Approval was granted by the Minister, but negotiations with the NIA came to naught, and a unit within SARS was established instead. Known initially, so it seems, as Special Operations, it was then called the National Research Group, which was later disbanded, but 6 members were retained as the High Risk Investigation Unit. It reported to Mr. Johan van Lachrenberg, who reported in turn to Mr. Ravel. Why such a unit was considered to be unlawful is not clear to me. And that's the paragraph I read to you early on, and it's the one quoted in the affidavits and in the report. And then it goes on. Maybe I must just read it again so that we can see the context of paragraph 10. Why such a unit was considered to be unlawful is not clear to me. While the National Strategic Intelligence Act prohibits the covert gathering of certain intelligence, that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax. That members of the unit might at times have acted unlawfully, that SARS employment policies might have been breached, that members might unlawfully have acquired and used equipment, all of which came later to be alleged. I see no reason why SARS was and is not entitled to establish and operate a unit to gather intelligence on the illicit trades, even covertly within limits. Indeed, that was the view expressed to SARS in late 2015, which seems not to have been made public by SARS. An opinion was furnished to the former Commissioner of SARS on about 1 September 2015 in response to the findings of a panel chaired by Advocate Sikhakhane SC, by Advocate Trengov SC and Advocate Nkumalo, who advised that SARS, 1, may keep people under surveillance in the public domain, but not in private, may follow a person or vehicle in the public domain, but not in private. Go down. Probably may place an electronic tracking device on property to trace its movements. It may, however, not place an electronic tracking device on a vehicle to follow the movement of its driver because it impinges on his privacy. May watch a person or property such as business premises, residences, containers, etc., but only in the public domain. May take photographs or videos of people or property in the public domain, but not in private. May not listen or record private conversations unless a SARS official is a party to the conversation. May not electronically record third-party conversations by using listening devices. May record conversations between SARS officials and third parties. May accept information from informers on the basis that their identities will not be revealed. May accept information from a person even if it knows that the information was unlawfully obtained. It may, however, not accept stolen property. It was said to be unlawful by a panel chaired by Advocate Sikhakhane, but I find nothing in his report to persuade me why that is so. Advocate Sikhakhane was asked if he could elaborate, but his reply took it no further than what was said in the report. The SARS Advisory Board, chaired by Judge Kroon, reported to the Minister and issued a media statement saying the unit was unlawful, but in evidence he told the Commission that that was not a conclusion reached independently by the board, but had been adopted from the Sikhakhane panel, and he had come to realize it was wrong. Indeed, he supported the re-establishment of capacity to investigate the illicit trades, which we recommend. Go down. The panel chaired by Advocate Sikhakhane SC. In early 2014, Mr. Johan van Lachenburg was engaged in what appears to have been a turbulent romantic relationship with Ms. Belinda Walter. In about May 2014, in an apparent fit of pique for a breakdown of the relationship, Ms. Walter lodged a complaint against Mr. van Lachenburg with SARS. She alleged, amongst other things, that in the course of the relationship, Mr. van Lachenburg had unlawfully disclosed taxpayer information to her. The allegation came to the knowledge of the media, which reported on it sensationally. Mr. Pillay was the acting commissioner at the time. He appointed a panel to investigate the complaint. In August 2014, the panel produced a 3-page report that was inconclusive. We will argue there's a difference in the status of the Nugent Commission report, the Nugent Commission being a commission that was appointed with subpoena powers, in other words, the exercise of a reviewable function, as opposed to a panel comprising of 3 advocates, essentially rendering an advice to SARS, the former being what is reviewable and the latter not. And that's why I said I'll draw the distinction between the two. So even if you had any inkling of you wanting to review the Sikhakhane Commission report, given the nature of the report, it's not a document that's an exercise of a public power or the performance of a public function that one can review. And so we will argue that later. You will recall many months ago, Mr. van Lachenburg had actually testified that they had sought legal advice on whether they could in fact review the report, and the advice provided to them was that it wasn't a reviewable report. I'm just interjecting that to put a context into why I draw the distinction between the 2 reports. In September, and we will deal with the relevant law when if asked to do so in final argument, in closing argument. In September 2014, Mr. Pillay appointed another panel comprising Advocate Musi Sikhakhane SC, Advocate Nasreen Rajapadlinde, and Advocate Patrick Romano, with terms of reference arising from the complaint against Mr. van Lachenburg. Before its investigation was complete, the allegations in the Sunday Times were published, which it then investigated. The reason for doing so was expressed in the report as follows. The existence of the NRG was not volunteered to the panel until it was revealed in the media. The panel independently found sources that had been part of this unit since its inception, to the extent that the existence of this unit has been at the center of the complaints against Mr. van Lachenburg. We investigated its origins. We also investigated its origins simply because our terms of reference included the investigation of any other matter that we deemed deserving of such investigation. And shortly after the panel was appointed and commenced its work, the media reports escalated and alleged the existence of a COVID unit that had been operating at SARS. By this time, we had already interviewed some SARS officials, including Mr. van Lochenberg. It must be stated that the existence of such a unit in any form was not specifically part of the terms of reference. However, the terms of reference extend, in our view, to the consideration of the existence and operations of a COVID unit to the extent that we had not considered such issues once they become apparent, we would have failed in our obligation to fully respond to our mandate. Judge Nugent just says in a report dated 5 November 2014, the panel reported, amongst other things, that at the HRIU, the High and its predecessors had been established unlawfully, that the recruitment, funding, and practices of the units might have violated SARS's human resources policy, and that the unit should be disbanded. It had already been disbanded in October. And then he goes on and he says, I dealt in the introduction in this report with the repeated attempts in various ways to resuscitate the alleged rogue unit before this commission. I have said as well that what members of the unit might or might not have got up to is not the concern of the commission, and if unlawful acts were committed, the remedy is to report them to the authorities. The alleged rogue unit is relevant to this commission only insofar as it explains the consequences of the revelations in the Sunday Times. And then he goes on and he says he deals with the resignation of Mr. Pillay. And he says one of the early steps taken by Mr. Moyane, which must have been in about mid-October 2014, was to cause Ms. Khumalo, the Chief Officer of Human Relations, to obtain an opinion from SARS attorneys on the lawfulness of a payment received by Mr. Pillay from the pension fund upon taking early retirement and his subsequent reappointment under contract. In essence, in the event of early retirement, the member is entitled to the benefits that have accrued to him or her, less a penalty calculated according to a formula. If the member retires with full benefit that has accrued, the employer must make up the penalty to avoid an accrual shortfall in the fund. That is what occurred in his case. Mr. Makashula was the Commissioner of SARS at the time, and Mr. Godan was the Minister of Finance. Mr. Flock Sumington, a lawyer employed by SARS with particular knowledge of pension rights, expressed his opinion that the arrangement was lawful. Mr. Makashula approved and recommended the arrangement for approval of the Minister of Finance, who was Mr. Godan, saying that a similar arrangement had been made with other employees many times. According to an affidavit deposed by Ms. Minnie Hendricks, who had been seconded to assist Mr. Godan in his position as Minister of Finance, she brought the request to his attention and he asked for more information. Mr. Godan raised the matter with a number of people over the next 3 months, including the chairperson of the SARS Remuneration Committee, before he granted the request. The opinion furnished by SARS attorneys on 5 November 2014 was that the arrangement was indeed lawful. Also, by what must have been about mid-October 2014, Mr. Moyane had decided to appoint a firm of forensic consultants, KPMG Services Pty Limited, to carry out investigations for SARS. The contract for the provision of its services was signed for SARS on 27 October 2014, was signed by KPMG on 29 December 2014. Also on 29 December 2014, a service request was issued by SARS specifying the scope of the investigation to be undertaken, which was to perform independent investigative tasks that was required to be focused on the conduct of Mr. Pillay, Mr. Richer, Mr. van Lochenberg, and Mr. Picky, who were subsequently dismissed on unrelated grounds, referred to particularly but not exclusively in the report of the Sikhakhane panel. According to the report produced by KPMG, its investigation entailed an average of 20 to 30 professionals who together reviewed 860,000 email imaged from 23 computers that had been seized and considered in excess of 1.36 million documents going back as far as 2003 at a cost to the taxpayer of about 24 million, which has since been repaid to SARS. The cost to the taxpayer for the lawyers who participated in the process can be assumed to have been some millions more. We do not consider it helpful for achieving the purpose of this inquiry to delve into questions that arise concerning the preparation of that report. Meanwhile, On about 11 November 2014, Advocate Brassie SC recorded in a memorandum for SARS that he had been instructed, based on the reports that had appeared in the media, that Mr. Pillay may be implicated in acts of malfeasance, and he was asked as a matter of extreme urgency to consider whether there is potentially any substance in the suspicion currently entertained, and if there is, make recommendations of a very preliminary nature on how the matter can best be investigated and ultimately brought to finality. I think it is clear that by then the Sikhakhane panel had not yet delivered its report to SARS. Having been furnished with a handful of documents and having a short consultation, Advocate Brassie said, in the course of the consultation that I had with my instructing attorneys, they explained that it might be necessary to suspend Mr. Pillay pending the outcome of these investigations. I can see little basis for taking so drastic a step at this juncture. If suspension is ultimately invoked, it should only be at the stage when Mr. Pillay demonstrates an obdurate refusal to cooperate, or in following the requisite interviews with him and others, it appears that there is indeed a case to answer. In deciding whether to suspend, my consultant should appreciate that suspension is typically required in circumstances such as the present only if there is some reason to suspect that evidence or witnesses will be corrupted. Before Mr. Pillay is suspended, I hasten to add, he should be told of the substance of the possible charges against him and of the reason why suspension is being contemplated. He should be invited to respond to these statements by explaining why suspension would be inappropriate in the circumstances. The report of the Sikhakhane panel signed on 5 November 2014 was later furnished to Mr. Moyane, who handed it to Mr. Pillay. Mr. Pillay responded to the report on 3 December 2014 with a 34-page critique taking issue with various findings of fact and law in the report. He sent the critique to Mr. Moyane and requested permission to circulate the critique among senior members of management. Mr. Moyane's response the following day was extraordinary. I acknowledge receipt of your envelope with 2 sets of documents. I have not read the 34-page document. I cannot approve your request to circulate the report to the chief officers. At this stage, I do not consider it appropriate that you share your views with the chief officers, as this would be construed as an attempt to influence or impose your own views on them. Regarding the advice that Mr. Pillay could be suspended only if there was reason to suspect that evidence or witnesses would be corrupted, and that he must be given the opportunity to respond to why he was being suspended, Mr. Moyane called Mr. Pillay to his office on 5 December 2014 and handed him a notice of suspension. Mr. Pillay told him that he had responded to the allegations in his 34-page critique, to which Mr. Moyane replied that he had not read the critique and did not intend reading it, as it was no more than Mr. Pillay's opinion. Mr. Pillay challenged the suspension in the Labour Court, which ordered SARS to withdraw it on 18 December 2014 on the following grounds. On the facts of this matter as they had been presented in the papers, it appears that the applicant has not been afforded an opportunity to make representations before the decision to suspend him was made. I draw the conclusion, despite the Commissioner's averment, that he invited the applicant to make submissions. The following day, Mr. Pillay was invited to make submissions as to why you should not be placed on precautionary suspension pending investigations into various allegations against you, and given reasons for the proposed suspension, to which he was invited to respond. I think it can be taken that this was no more than a formality. Mr. Moyane had earlier declined to read Mr. Pillay's critique, and there is no reason to think he had now changed his mind. Mr. Pillay responded on 14 January 2014. On 21 January 2015. On 21 January 2015, Mr. Moyane wrote to Mr. Pillay rejecting his submissions and advising that I have decided to place you on precautionary suspension pending an ongoing investigation, including a forensic investigation conducted by KPMG into allegations of unlawful conduct within SARS in which you have been implicated. Thus, within weeks of Mr. Moyane's arrival at SARS, 3 things had happened. He had suspended Exco for reasons not explicable on any rational grounds. He had asked for an opinion on the lawfulness of Mr. Pillay's pension arrangement. He had decided to employ KPMG to conduct investigations which turned out to be concentrated on Mr. Pillay and others. A month or so later, he refused even to read Mr. Pillay's response, but yet suspended him. There is no apparent reason why Mr. Moyane would be asking for an opinion on the lawfulness of Mr. Pillay's pension arrangement when no issue had arisen around it, from which I think it can be inferred that one of the first things he did was to call for Mr. Pillay's employment file. Why would he then ask for an opinion on the lawfulness of an arrangement long in the past when no issue had arisen around it? Which employer would spend what must have been about 30 million or more to investigate an alleged transgression or transgressions on the part of 4 employees? An employer who genuinely wanted to know whether proper procedures had been followed in appointing staff 7 years previously might just as well have asked the employment division. If the employer wanted to know who had bought equipment, one might expect the relevant accounts department to be asked. If he or she had wanted to know what the staff had been up to, one might expect the head of the division to have been asked to investigate and report. None of that called for KPMG to be the first port of call at the cost of millions. Mr. Lebello suggested that Advocate Brassey had advised on 11 November that a forensic investigation was called for, which is correct, but that was after SARS had already signed the KPMG agreement. And if an employer wanted to know what had happened in 2007, why would its investigators trawl through documents going back to 2003? And which employer acting bona fides would refuse to read the employee's explanation for his alleged conduct before suspending him? Go down. Then add the case of Mr. Richter. He too would serve and was served a notice of suspension on 5 December 2014 by Ms. Khumalo in the presence of Mr. Lebello, but they were unable to furnish reasons for his suspension, as Mr. Richter recorded on the notice of suspension. And then there's an annex that's annexed and provided to Judge Nugent. Put together those facts, and in our view, the inference is inescapable that Mr. Moyane was bent from the start in getting rid of them and set about finding a basis for doing so, on whatever grounds that could be found. He had, after all, been advised by Bain that he should neutralize those he thought might hamper him, and Mr. Pillay was certainly considered to be one. On 5 February 2015, notice was given of disciplinary steps against Mr. Pillay on 10 charges. 9 charges related directly or indirectly to the rogue unit. The 10th charge related to the pension arrangement. The proceedings was to take place before retired Chief Justice Nkobo. On 29 April 2015, Advocate Brassey and his 2 juniors addressed a memorandum to the instructing attorneys not included in the files produced by Mr. Lebello, recording a consultation the previous day. Yesterday, we recommended to our client SARS that of the 3 sets of charges currently being pressed against Mr. Pillay, SARS Deputy Commissioner, it is not clear in which categories each of these charges have been placed. The charges concerned with the so-called rogue unit should be held in abeyance. Our advice was premised on the fact that the evidence, so far as we have been able to gather it, is far from conclusive on these charges, and that witnesses who might be called to substantiate the case were proving to be uncooperative. In response, our client, represented by Mr. Luther Lebello, has instructed us that all 3 charges should be pressed together, and we happily submit to such instructions. Furthermore, the documentary evidence on the activities of the rogue unit is presently advised thoroughly unsatisfactory. All we really have are the dashboard reports that were made by the unit from time to time to SARS top management. Mr. Lebello said in evidence that it was not he who had given the instruction, but that it emanated from discussions amongst them. But I see no reason not to accept what Advocate Brassey said in the contemporaneous memorandum. Meanwhile, Mr. Pillay had wanted to resign, and there had been discussions mediated by an intermediary of the terms upon which he could do so, but they had been inconclusive. By 6 May 2014, however, soon before the disciplinary proceedings agreement was reached, Mr. Pillay resigned. A separate and settlement agreement was signed by him and SARS, in which he agreed to resign with immediate effect. Included in the agreement was what was called the restraint of trade, in exchange for which he received payment of a sum equivalent to 18 months' salary. Mr. Peter Richer was employed by SARS from August 2003 to July 2006, and then again from July 2009 until he resigned in May 2015. He was Group Executive Strategic Planning and Risk. From July 2014 to October 2014, he was Acting Chief Officer, Strategy, Enablement and Communications. Much the same happened to him as to Mr. Pillay. The report of the Sikhakhane panel had made no suggestion that Mr. Richa might have been implicated in any wrongdoing. Yet on 5 December 2014, Mr. Richa was served a notice of suspension at the offices of Ms. Khumalo in the presence of Mr. Rebello, albeit that no reasons could be given for his suspension, as Mr. Richa recorded on the notice, unable to provide reasons at this time. He too approached the Labour Court and his suspension was withdrawn, only to be imposed again in January 2015. On that occasion, allegations were put to him relating to the road unit, and he was invited to make representations, which he did, but they were rejected. Disciplinary proceedings were also commenced against him. Mr. Richa resigned at the same time as Mr. Pillay and on the same terms. Asked by the Commission to explain his resignation, he said that it was in order to remain sane and to proceed with my life. The resignation of Mr. Raval. In November 2014, said Mr. Raval in evidence he was summoned to Mr. Moyani's office. And Mr. Moyani came down on me like a ton of bricks, accusing him of being a weak leader and saying he must choose where he stood, either with Mr. Pillay or with Mr. Moyani. For a while, his relationship with Mr. Moyani appeared cordial, but in early 2015, said Mr. Raval, he realized he was on his way out when he attended a presentation where he disputed some of the material that was presented. Sometime later, he was summoned by Mr. Moyani, who said alleged criminal activity on his part was being investigated. A few days later, a criminal complaint against him was laid at the instance of Mr. Moyani. On 19th May, he was called to the office of Mr. Moyani and presented with a letter from the Hawks confirming that a criminal complaint had been laid against him, and he was told the investigation might take months and that further charges might be made. Mr. Moyani said he should expect to be suspended. The following day, he was again called to the office of Mr. Moyani, where he was presented with a letter of suspension, and he resigned. He was asked to sign a restraint, in return for which he was paid 6 months remuneration. Mr. van Lachenberg. Mr. van Lachenberg was at one time Group Executive Enforcement Investigations. The HRI unit reported to him and he reported in turn to Mr. Raval. I have related the circumstances in which he found himself being investigated, first by the panel chaired by Mr. Kanyeli and then by the Sikhakhane panel, which made findings against him. I have not taken to the committee to the investigation of Mr. Kanyeli, whose findings were inconclusive. Mr. van Lachenberg was suspended on 12 November 2014. On 15 January 2015, disciplinary proceedings were commenced against him. Meanwhile, Mr. van Lachenberg had to contend with relentless media articles humiliating him and advancing allegations to which his terms of employment prevented him from responding. By then, he was considering resigning, and he conveyed to Mr. Moyani. He was asked to present the proposal in writing, which he did. He met once again with Mr. Moyani, who insisted that he delete parts of the letter he had written in which he had protested his innocence. He duly resigned on 4 February 2015 at the office of Mr. Moyani, receiving the equivalent of 6 months remuneration in return for signing a restraint. Mr. Moyani insisted on a photograph being taken of the two shaking hands and smiling, and the resignation was cynically announced as amicable. I'm going to skip Mr. Hall because it doesn't fall within the context of this report. Go to paragraph 50. The evidence of what occurred at that time, both the oral evidence and that contained in many documents, of which the above is only a stark summary, has a distinct atmosphere of frenzy about the so-called rogue unit, in which even parliamentarians might have got caught up, much like the frenzy at the beast in William Golding's Lord of the Flies. Mr. Lebello calls it a media narrative that Mr. Pillay, Mr. Richa, Mr. van Lachenberg, and Mr. Raval were driven out of SARS. He says they all resigned because they feared the disciplinary proceedings they were facing, as he wanted to prove with his files and his affidavits. Perhaps that is correct, and for present purposes we'll assume that to be so, but it misses the point. It is clear there was an intention at the outset to drive them out of SARS. The disciplinary proceedings might ultimately have achieved that purpose. Is neither here nor there. One thing they could all be sure from the start, there was no place for them at SARS. And that was the gist of the Judge Nugent's consideration of aspects dealing with the unit and the subject matter that was before the public protector and the relevant parts. There is an extensive conclusion in the Nugent report of general recommendations, which isn't material for what this committee needs to consider. Chair, there's a hand up, I think. No? Okay, okay.
Well, on that point, we'll take a 10-minute break, tea break. And we'll be back after 10 minutes. Just for tea break. Thank you.
Recording stopped.
taking the members into the Nugent report for purposes of placing it into context, but I want to go back to where I was in the affidavit of Mr. Pillay in response to the subpoena. And we had read the excerpt, the one paragraph from in paragraph 31.7.9. You put it on the screen of the Nugent Commission report, and I go to 31.7.10. Right? So we've contextualized the Nugent Commission report in the context of the subject matter of the Public Protector's report, and Mr. Pillay's affidavit in response to a subpoena to him had only encapsulated the one paragraph in that affidavit. He then in paragraph 31.7.10 says to the Public Protector, a subsequent admission by retired Judge Kroon under oath in March 2019 that all the members of the so-called Kroon Advisory Board had deliberated the statement between May to June 2015 that the unit was unlawfully established, as put forth by the so-called Sikhakhane panel. The Kroon Advisory Board then concluded that it was indeed wrong to have concluded this. So what is recorded by Mr. Pillay under oath to the Public Protector is not simply the apology, but it went further than that. It then said, these facts can be determined from retired Judge Kroon and the members of that board directly. And at 31.9, it says, however, public records exist that set out in detail the legality of the unit, its establishment, mandate, and its existence had been public knowledge for years and explained in detail. And then he sets out Annex D, and in particular paragraph 5.21 thereof. In this regard, I personally participated in briefing members of Parliament, the Presidency, the State Security Agency, and parliamentary committees on these matters since 2010. 2. My submissions to the Sikhakhane panel. My submissions to the Sikhakhane report addressed to Mr. Muyani. The so-called snowman broken arrow bundle, which I attach marked F. Various letters and minutes of meetings and documents provided to the Presidency, South African Police Service, State Security Agency, various members of Parliament, Ministry of Finance, and parliamentary committees between February 2010 to 2014. A best-selling book entitled Killing for Profit, Exposing the Illegal Rhino Horn Trade in the chapter Juju and the Poacher, published in 2012, names the unit openly associated with SARS and explains its mandate. The book has, to my knowledge, been republished 6 times since then. Then he also provides a charge sheet in which he has been criminally charged, and that is to be found at PDF 427. Actually, don't go down. I just want to show that it's an X. The reason why we're not going down is because the address of those who are charged, which include Mr. Pillay, Mr. van Lochenberg at that time, is provided. And this submission was made to the Public Protector in April 2019. So by that stage now, I don't want to, the addresses are not blanked out to do that. Right? So if we go to page 445, Mr. Pillay is then served with a Section 7(9) notice, and this is the affidavit which he then provides the Public Protector in response to the Section 7(9) notice. This is also annexed to his papers before, to the affidavit of Mr. Godan, the founding papers before the High Court. And I want to draw your attention to a few of those paragraphs. Let's go to paragraph 9. Where he draws particular attention that the fact that in paragraph 14.4.33 of the notice, the Public Protector concludes on the strength of the evidence before her that Mr. Andries Janse van Rensburg and Mr. Pillay are guilty of the very charge, let's read it in the first person, that we have been indicted for, the trial of which is presently pending in the High Court Gauteng Division. The Public Protector impermissibly seeks to preempt the outcome of the trial. In doing so, she tramples on my constitutional guaranteed rights to a fair trial. I wish to point out that the National Director of Public Prosecutions has embarked upon the process set out in Section 179(5) of the Constitution to review the decision to prosecute. It appears that the Public Protector seeks to influence that process to my detriment and to the detriment of Mr. Janse van Rensburg by predetermining and proclaiming our supposed guilt in our intended report. Mr. Pillay then makes certain in general comments, which he starts at paragraph 15. Some of the other paragraphs are background or have appeared in the affidavit that I previously brought to the committee's attention. And he says, I place on the record that I do not agree with what the Public Protector describes in the notice as a intended, likely, provisional or preliminary findings, which terms are used interchangeably in the notice in their totality. I shall simply refer to them in this affidavit as findings. In my view, the findings amount to misrepresentations and distortions of the truth to the actual and potential prejudice and detriment of me and others, SARS and the country as a whole. The notice is replete with loosely used terms, specifically the term COVID and intelligence, that are not defined in law and are also not defined or explained in the notice. In this regard, I record that neither COVID and discrete investigations, nor the practice of collecting intelligence, nor the practices of collecting actual or potential evidence, finding information that would guide investigations, investigating, identifying witnesses and whistleblowers, and determining the location of actual or potential evidence discreetly, covertly, or under protection of SARS confidentiality legislation directly related to serious offences against SARS, inter alia tax evasion, customs invasion, excise invasion, fraud, smuggling, racketeering, money laundering, and corruption can remotely be considered as improper, unlawful, illegal, or questionable in any manner or form. The only limitation in law in this regard relates specifically to conducting covert intelligence, specifically in relation to national security matters, which are both terms defined in law. The Public Protector, in determining what she repeatedly refers to as the rogue sick unit as being unlawful, has effectively neutered the entire enforcement capability of SARS, the result of which is clearly legally untenable and patently irrational. I further place on record that what the Public Protector has set out in the notice as constituting the reason and basis for findings demonstrate that the findings are neither rational nor reasonable. The findings are as a result from errors of fact and law. The Public Protector has failed in the investigation to be proactive, impartial, and determined in the investigation, and to retain an open and inquiring mind in the course thereof. The Public Protector has approached the investigation in a biased manner. Public Protector relies on false representations made by various parties and accepts and presents these as if fact. Several statements contained in the notice of the Public Protector are patently false and defamatory, and the Public Protector omits material facts and evidence at her disposal or accessible to her or available in the public domain, a proper considerations of which would have resulted in her findings being completely different. Furthermore, the Public Protector has deliberately omitted to reflect detail and consider materially relevant factual evidence and facts which demonstrate organized and coordinated efforts by various parties and groups. One, to disrupt and cause chaos at SARS, hound people out of SARS and humiliate them that they can never find work again. Unlawfully and illegally spy on, attack and discredit SARS and its officials, and audits and investigations, including the Finance Minister, Mr. Pravin Gordhan, Mr. Johan van Lachenberg, and others at SARS, including me. Replace the leadership of SARS and remove the Minister of Finance. Facilitate the ultimate state capture of SARS as institution. And 6, commit serious offences against SARS, inter alia tax evasion, customs evasion, excise evasion, fraud, smuggling, racketeering, money laundering, and corruption. These omissions by the Public Protector pertain in the main to a deliberate and false propaganda campaign in relation to what has notoriously been referred to as the SARS rogue unit. This campaign of disinformation commenced in earnest in the popular media on 12 October 2014 and has continued ever since with the assistance of inter alia, current and former SARS officials, state intelligence operatives, and law enforcement officials, taxpayers in dispute with SARS, and politically connected individuals and select persons in the media. The Public Protector has failed to properly investigate the matters in their totality. The notice contains intentional, unlawful misrepresentations to my actual and potential prejudice. The findings, as well as a public statement by way of video distributed on social media, issued by the Public Protector on 3 June 2019, when she revealed that she was serving a Section 79 notice on Minister Gordhan, and the Public Protector's further utterances at public speaking venues in official capacity serve to advance the rogue unit propaganda campaign. In the 3 June 2019 communication, the Public Protector had already announced to the public her findings by referring to the existence of a rogue unit. In that statement, the Public Protector, amongst numerous other false and defamatory utterances, falsely and in a defamatory manner, cast me and others involved in the same light as murderers. In this regard, my attorneys addressed a letter on 14 June 2019 to the Public Protector on my behalf, copy of which is annexed. On 17 June 2019, the Public Protector's attorney sent a dismissive, emotional, and threatening response. Next, the Public Protector appears to have adopted a position that will brook no disagreement with her, which assumes that any challenge to her utterances, whether on social media, in public address, or in her reports, amounts to interference with her work. There was no rogue unit. The Public Protector, as evidenced by the content of the letter of her attorneys, dated 17 June 2019, appears to believe that this loaded appellation is perfectly proper because it is commonly coined and publicly known. And in the absence of a court order prohibiting its use, the appellation remains usable by all South Africans, including the Public Protector. I submit that, contrary to that belief, stubborn and deliberate use of the term rogue unit by the Public Protector in circumstances where the very issue that she is investigating is whether or not the unit was lawful, demonstrates her bias and closure of her mind to any outcome to her investigation other than one which upholds and confirms the rogue unit narrative. The notice issued by the Public Protector indicates that the findings are dealt with in a first part, which will be followed by a second volume. The notice then relates to the first part as set out in paragraphs 8.1 to 8.6. I do not intend to refer to any of the matters that the Public Protector has decided to defer to her intended second volume. I merely remark that this is a strange way of conducting an investigation and appears aimed at involving those likely to be implicated in the second volume in additional cost and effort. It seems clear, however, that the Public Protector wishes to expedite the publication of her contribution to the rogue unit narrative. At paragraph 28, it then starts dealing with evidence. Notice uses the term evidence loosely throughout the content. In this regard, I've been advised that evidence is not simply allegation, but factual material which might prove or disprove the allegation in question. The notice is replete with conjecture and speculation described as evidence, and apparently relied on by the public protector as if it was actual evidence. Evidence not given under oath generally carries little weight. It is also well established that the existence of a document or recording does not constitute proof of the correctness of the content of the document or recording. Courts of law and tribunals such as the public protector, which investigate and report on allegations, make findings of fact based on evidence and draw conclusions based on those factual findings and the law. A statement or allegation made by someone that certain evidence exists or that certain events occurred is neither a finding of fact nor a final conclusion. Prima facie evidence is generally accepted by courts and fact-finding tribunals to mean evidence which, in the absence of rebutting or contrary evidence, furthermore, and then he refers to the oft-quoted case of Sample, the citation is there, where the SCA had stated that primary facts are facts which are directly established by evidence. It is secondary facts are facts which are established by inferences, by inference from the primary facts, and that the drawing of an inference for the purposes of establishing a secondary fact is also a finding of fact. With regard to the drawing of inferences, our courts have repeatedly quoted with approval the following statement. This must be carefully distinguished from conjecture or speculation. There can be no inference unless there are objective facts from which to infer the other facts which it is sought to establish. But if there are no positive proved facts from which the inference can be made, the method of inference fails, and what is left is mere speculation or conjecture. South African courts have also consistently affirmed that in considering reports by the public protector, the court will interfere with and overturn a finding and recommended remedial action if there is not a rational objective basis which justifies them. The notice is replete with speculation and conjecture. It is extremely difficult to follow and make sense of it because it is clearly rushed to completion, exhibiting scant, if any, regard for facts and evidence relevant to the complaints. And then he says he's going to set out issues that he deals with. Facts, references, evidence, the location of such evidence, and witnesses and records, many drawn from the public domain, and all of which are material to the matters raised in the notice. Without exception, they have all clearly been ignored by the public protector during her investigation. If you go to paragraph 32 and following, he deals with the establishment of the unit as explained. And he says, I wish to recall that the notice demonstrates a complete lack of understanding or even an attempt of understanding SARS as an institution, its various enforcement and investigative units over the years, 1998 to 2014, the legal and policy framework with which these units operated, their mandates and how they functioned, as set out in my submission. In the result, the notice reflects cardinal factual errors and untruths, which I deal with specifically later in this affidavit. For instance, the notice confuses separate SARS business units that reported to completely different divisions and subdivisions under completely different management structures with completely different budgets, oversight controls, organizational attributes, functions, and purposes. And he gives one example as an elementary example. The notice confuses the CBCU, which resorted under customs operations, with the National Research Group, which reported to the subdivision, which in turn resorted under Enforcement and Risk Division. In turn, a further confusion is added by confusing the AKAS, which was a standalone division, and the AKAS dealt with corruption, reporting to the General Manager, Risk and Enforcement, and later to the SARS Commission. Similarly, at inception, the Special Project Unit was a small subunit under the CBCU division, and shortly after transferred to an entirely different division named Enforcement and Risk. And so he goes on and he explains a legal opinion, some of which we have already read to you. And I want to take you specifically to paragraph 82. It has been stated on record, wrongly so, by SARS spokesperson, in particular Mr. Luther Lebello, at various times that I, as acting SARS commissioner, had initiated investigations into allegations of a rogue unit at SARS. This is false. Got that? I wish to record certain key aspects regarding these processes. And then he says, former SARS Commissioner Tom Moyane started at SARS on 1 October 2014 after his appointment was announced. The Sikhakhane panel concluded its report on 5 November. The notion of a rogue unit in the scope of the panel's report was introduced by the panel itself sometime later in October 2014. The Sikhakhane panel stated this in the report. Paragraph 757 says, it must be stated that the existence of such a unit in any form was not specifically part of the terms of reference. However, the terms of reference existed in our view to the consideration of the existence and operation of a COVID unit to the extent that we had not considered such issues. Once they became apparent, we would have failed in our obligation to fully respond to our mandate. If you then go to paragraph 83.6, Sikhakhane panel's paragraph also admits by the time the panel had decided to extend its mandate to include allegations of the unit, they had already interviewed SARS officials and therefore did not hear them on any of these allegations. The report states that by this time we had already interviewed some SARS officials, including Mr. van Lochenberg. Therefore, contrary to what some would want the public to believe, the Sikhakhane panel was not instituted by me to investigate allegations of a rogue unit or any SARS unit, and clearly by their own account, the members of the panel took this upon themselves on a date around 12 October 2014, after hearing without hearing multiple persons on these allegations, without informing me, and in particular not hearing Messieurs Johan van Lochenberg, Andries Jansen van Rensburg, or Peter Richer. Not only do I take issue with the factual, flawed, and contradictory nature of the content of the Sikhakhane panel report, as set out in my critique, but also with what the report ignores and omits. In this regard, here I specifically referring to serious criminality and the motives of those behind the allegations against SARS and its officials. I also specifically refer to the obligation which rested on the panel to report evidence placed before it in terms of Section 34 of PRECA as amended, and the failure to do so being a criminal offence. In addition, despite what some would want the public to believe, the Sikhakhane panel made no adverse findings against me or Mr. Richer. This was confirmed publicly by the instructing attorney of the panel, Mr. Imran Mohammed, who stated that the panel had made no findings against Pillay or Richer. He stated that no such findings were made against any third party. So no finding was made against the Deputy Commissioner, Mr. Ivan Pillay or Mr. Richer. The Sikhakhane panel is profoundly flawed in fact and law. I've already provided the Public Protector with my critique, but this had not been reflected on in the notice. I wish to quote 2 paragraphs from my critique. Based on the procedural and substantive and general deficiencies in the report as detailed above, I'm of the view that the report poses a significant and unwarranted risk for SARS if the report were to be published in its present form. The report also has the potential to tarnish not only the reputation of SARS, but also the reputation of those who are implicated by the unfounded opinions and the recommendations of the report. In light of the above, I recommend that the report, together with its response and all other relevant material, be referred to a retired judge from the Supreme Court of Appeal. Every party that is affected by the issues in the report should be allowed to make representations to the judge. The judge would then make factual findings available for the Commissioner so that he can decide on the best course forward. Got that? I'm aware that the Sikhakhane panel report was challenged by Mr. van Lachenberg, both to SARS and the so-called Kroon Advisory Board. Parts of such have been published in the public domain, in which the Public Protector has had no regard to in the notice. Having regard to what is stated, in support of its findings and recommendations, it is clear that the report is materially flawed in fact and law. Any reliance by the Public Protector for any purpose on the Sikhakhane panel report is irrational in place. This is especially so in circumstances which have been challenged and rebutted formally by several people, including me, and in as much as these challenges have not been considered and reflected in the notice. This is further compounded by the fact that the very complainant who led the original allegations that caused the institution of the Sikhakhane panel, Ms. Walters, has pointed out significant and fatal flaws in the Sikhakhane panel report under oath before the High Court, as pointed out by Mr. van Lachenberg. And then it goes to the KPMG report that I'm coming back to. Go to paragraph 97.4. Up just to 97 so we can get the file. Then what is contained in the notice is once again a manifestation of ever-changing allegations by way of example, and then you go to 97.4. The allegation again changed with the introduction of the vague and unexplained finding by the Sikhakhane panel that the unit was unlawfully established. Sikhakhane panel paid scant regard to the unit's activities over the 7 years of its existence to inform this view. To the limited extent that the Sikhakhane panel did reflect on the work of the unit, it said the following. Negotiations were commenced between SARS and NIA, but did not progress to a point where the plan became a reality. As fate would have it, when the negotiations failed, SARS had already started gathering the required personnel experience in intelligence work and already started conducting limited intelligence work against organized crime. It is generally accepted that the unit never progressed to conduct anything more than the limited intelligence it did when it started. This limited intelligence work entailed desktop research and physical surveillance tracking with the use of borrowed vehicle tracking devices, 2 or 3 cases in its entire lifespan. It is also generally accepted that the efforts of this intelligence team had impressive returns against organized crime throughout most of its existence. Through its work, the unit has been able to contribute immensely to the creation of the best revenue service in the continent and one of the best in the world. Further, notably, all of those we interviewed who knew about the NRG/HRIU and or were part of it remained adamant that the unit did not have the capacity to intercept communication. In fact, all the unit's operatives, both in respect of the old NRG and the new HRIU, either asserted that the unit did not have equipment to carry out electronic surveillance and or interception of communication, or were uncertain about whether such surveillance and or interception of communication had occurred or not. However, as a general rule, it was accepted that the unit did not have the required equipment to carry out such electronic surveillance or interception. Ms. Walters makes various allegations of other confidential taxpayer information having been disclosed to her by Mr. van Lachenberg, which is expressly disputed by Mr. van Lachenberg. The same applies in relation to alleged interceptions made by SARS. We had one. Go back up. Although he was indeed intimately involved in the functioning and later management of the NRG, there is no direct evidence linking him to any illegal interception of conversation of Ms. Walters or any other taxpayer. And then go to paragraph 141. says the allegations contained in the Sikhakhane panel report as quoted are emphatically denied. The Sikhakhane panel proffered no substantiation, rational or evidence whatsoever in support of these allegations. To the contrary, where evidence was provided to the Sikhakhane panel of serious efforts by members of other government agencies, including those tasked with investigating organized crime and collections of intelligence to undermine SARS, its work and its officials. This was ignored and not reflected in the report. Paragraph 142, he says, it is noted that the Sikhakhane panel report made a recommendation, and this was without having to put the and this was for a further investigation to be conducted. Mr. Pillay says it is denied, however, that this recommendation was ever seen through. In fact, the Inspector General of Intelligence has no jurisdiction over SARS in law. I have dealt with the purported report of the Inspector General of Intelligence and SARS-related responses here too. I have already dealt with the fact that the SARS unit's existence has never been denied by SARS. The facts of the matter are simply enough in public knowledge. And then, so he's put in an extensive submission in respect to the Section 7(I) notice. The report then comes out and the committee is familiar with parts of the report. I want to now go to the affidavits that has been filed in the litigation. Shepo, if you can go back to the note, evidence from the different reports. And what we've done is similar to what I did last week, is a table reflecting the allegations. Go down to further down. We've basically covered all of us. Come to the heading that says litigation, case 8.4, and go down. Go down. Down, down, down. Down, down, down. Down. Next page. There we go. Go up. Yeah. Further up. Of that page, I think. Go further up. Yep. Right. So what we have as a start is Minister Godan brings an application, which he does in Part A and Part B. Part A being to interdict the report, and Part B to have it reviewed and set aside, and he files a founding affidavit. The Public Protector then files an answer, and Minister Godan files a reply. Mr. Pillay comes in as an intervening party, and he files an affidavit to support effectively the relief sought by Minister Godan, and the Public Protector then files an answer to Mr. Pillay. And so in the first part, this only deals with the issues relating to the Sikhakhane report and the vermins in contrast, very similar to what we did last week, where I took out the allegations relating to the IGI report so one could see what was before the court and what had been alleged. And so Minister Godan states that the Public Protector relies heavily on the discredited report by the Sikhakhane panel in reaching erroneous findings. The Public Protector merely lists this issue as one of the allegations made by the applicant. No response to the relevant paragraphs of the founding affidavit, and she states that she will, for purposes of the interdict, confine her response to the allegations appearing from paragraph 158 of the applicant's founding affidavit. Right. And in the replying affidavit, the minister says, in addition, the main source relied on by the Public Protector's finding, and the EFF's case is now hopelessly and irredeemably tainted and can only be rejected because the discredited Sikhakhane panel reached an incorrect legal conclusion when it found the establishment of the SARS investigative unit contravened Section 3 of the National Strategic Intelligence Act 39 of 1994. Minister Gordhan's affidavit, which comes later, says, I wish to make it clear at the outset that I don't oppose the relief sought by Minister Gordhan in either Part A or B and fully supports the relief sought. The Public Protector says, I have addressed allegations made in the applicant's affidavit, which are largely repeated by Mr. Pillay. And when I deal with Part B of the application, which relates to the praise for the review and setting aside, she would deal with the allegations of Mr. Pillay's affidavit that relates to the review application. And she's only going to deal with Part A. So that's the landscape against which the Public Protector's initial answering affidavit must be considered. It's only dealing with the interim interdict. So I preface that because whilst there are certain allegations which are not answered for Part A, the Public Protector makes it very clear that she's going to deal with it in Part B. So one cannot take the view that the allegation is made undisputed. Go down. Right. The minister says the Sikhakhane panel rendered a report to Mr. Muyani that misapplied the law, erroneously concluded that the SARS investigative unit was unlawfully established. Right. And again, Mr. Pillay associates himself with the relief. Mr. Muyani used the Sikhakhane report to remove several SARS officials, reorganize SARS, cutting its enforcement capability and undermining its ability to ensure tax compliance by prominent political and underworld figures. This action on the basis of the Sikhakhane panel's report enabled in large part the recent capture of SARS as detailed by the Nugent Commission in his report. And then Mr. Pillay says Mr. Gordhan had annexed to his founding affidavit various references to two affidavits, which Mr. Pillay had provided to the Public Protector in the course of an investigation. And those are the two affidavits which I had just taken the committee through. So that's before the court. And then Mr. Pillay says that he set out in considerable detail in those affidavits the facts and evidence at my disposal relevant first to the investigation, to the extent that the Public Protector had revealed such to him, and to the intended findings of the Public Protector. Go down. Contained in a Section 7I notice to him. And then it says the Public Protector seems to parrot the conclusion of the Sikhakhane report that the establishment of the SARS investigative unit had contravened Section 3 of the NSI Act, which it said prohibits the conducting of covert intelligence gathering by structures other than that the National Defence Force, the SAPS, or the SSA. Pillay merely confirmed the contents of his affidavit. Go down. These affidavits don't necessarily run parallel. Just for ease of convenience dealing with it, but they don't necessarily correspond in paragraph numbers. Mr. Gordhan says that he was advised that the conclusions were clearly wrong in law, that the establishment of the SARS investigative unit did not contravene Section 3, its activities was not subject to the provisions of Section 3 at all. All right. Mr. Pillay complains about the fact that the Public Protector sought to rely on selective extracts of the discredited and contested so-called panel report, which had been addressed in his affidavit dated 18 June 2019, and points out that paragraph 75.3 of the Sikhakhane panel report details the nature and extent of the limited intelligence work that was carried out. Paragraph 82 then states that as a general rule, sorry, you're going too quickly. It was accepted that the unit did not have the required equipment to carry out such electronic surveillance or interceptions. The Public Protector simply ignored these inconvenient parts of the report. Mr. Gordhan simply complains about the reliance on the Sikhakhane report, and then he quotes, go down. He refers to the Nugent Commission report, go down. And he quotes the one paragraph that has been referred to the committee now on more than one occasion in respect of the Sikhakhane panel report, and I've read it to you out earlier. I'm not going to do it again. Go down. And the public protector ignores this finding of the Nugent Commission and instead clings tenaciously to the discredited conclusion reached by the Sikhakhane panel. Right? There is then a further affidavit dealing with Part B, which is not dealt with by the public protector at all. I'm going to come to what the public protector deals with, and in this regard, sorry, my apologies, I'm saying this incorrectly. The reference above is the date on which the Pillay intervention application affidavit was filed, 1 August 2019. Now we come to Part B. That is the part in which by then the public protector is now answering the substantive allegations dealing with the review application and the allegations which is related to the allegations found in Kodan's founding affidavit, right? To do that. And so in that regard, public protector says, okay, so by the time the public protector answers these allegations, we have already had the judgment in respect of Part A. And Patrol J has reached certain conclusions in that judgment. And so part of what the public protector answers in the answering affidavit also addresses what Patrol J had concluded in her judgment in that regard. So the PP says the High Court misdirected itself when it ruled that the public protector relies on the Sikhakhane panel's findings that the SARS investigative unit was unlawful because it contravened Section 3 of the NSI Act. Section 3(1) of the NSI Act prior to its amendment in 2013. Mr. Kodan submits that this section was not contravened because it applied only to those Department of States that were by law required to perform functions with regard to the security of the Republic or the combating of any threat to the security of the Republic. SARS was clearly not such a, you've gone too far. SARS was clearly not such a department. Furthermore, Section 3(1) did not prohibit all covert intelligence gathering, only covert departmental intelligence. Departmental intelligence is defined in the Act as intelligence about any threat or potential threat to the national security and stability of the Republic. She then explains that I found that the establishment of the SARS unit was in breach of Section 209 of the Constitution, in terms of which only the President may establish such covert information gathering unit. And then she quotes Section 209 of the Constitution and submits that SARS is not an intelligence service, and the definition of intelligence in the Act is in fact for purposes of informing any government decision, policy-making process carried out in order to protect or advance the national security. SARS is thus not affected by Section 209 as its application is confined to the establishment dedicated to the protection of national security. That's effectively the argument that was made there, right? Then the allegations that is made by Mr. Kodan, and I'm going to take it from 85 to 96 and then come back up to see what the public protector says in respect of those allegations. So Mr. Kodan says the public protector relies heavily on the discredited report by the Sikhakhane panel in reaching erroneous findings. Then says that they rendered this report to Mr. Muyani, and we've dealt with that. Mr. Muyani also used the Sikhakhane report to remove several SARS officials. We've dealt with that. And pointed out to the Nugent Commission thing. And then it says the public protector seems to parrot the conclusions of the Sikhakhane report that the establishment of the SARS investigation unit had contravened Section 3, which it says prohibits the conduct of covert intelligence gathering by structures other than the National Defence Force, SABC, and the Security Agency. And then I'm ever advised by my legal representatives that this conclusion was wrong in law. Stop, Cheryl. The establishment of the SARS investigative unit did not contravene it. Therefore, the public protector's reliance on the discredited and erroneous Sikhakhane panel's report in reaching any finding or imposing any remedial action is wholly misplaced and erroneous. Now let's see what the response was to those allegations. Mr. Godin's views are not necessarily shared by many lawyers. I was entitled to have regard to the many legal opinions expressed by different lawyers that she could access. It is denied, as will be shown at the hearing of this matter, that the Nugent Commission did not make any authoritative finding on the issue. At best, it was non-committal, even if it expressed some doubt. Further legal submissions will be made at the hearing of this matter. Mr. Godin has never sought to review and set aside the Sikhakhane panel report, so it is not clear on what legal basis he concludes that this report by an eminent senior counsel should be disregarded as discredited. The fact that some people, or even Mr. Godin, differ from Sikhakhane SC does not make the report discredited. Go down to para 101. These allegations were similarly found to be baseless in the final report of the Nugent Commission dated 11 December. And then it reads the other paragraph from the Nugent Commission report to which I referred you to. And the PP responds by saying, the Nugent Commission simply offered no legal analysis of the legal issues that Sikhakhane panel dealt with. Of interest in its view, that it is relevant for its view on the legal position that Advocate Sikhakhane SC did not respond to its offer to support the position in its report. The Nugent Commission does not commit itself to a legal analysis that helps to appreciate the doubts it has on the conclusions of the Sikhakhane panel report. In any event, I'm not bound by the findings of the Nugent Commission or the recanted position of Judge Kroon. Go down. 102. Somebody says the public protector ignores the findings of the Nugent Commission and instead clings tenaciously to the discredited conclusion reached by the Sikhakhane panel. Minister Godin, after the Rule 53 record is filed, then files a supplementary founding affidavit. And then there's a response from the public protector to that. And he sets out the list of peoples and bodies that have investigated the same issues. And I think we would need to go, Shepo, to page 929 of the document. PDF document. Just hold on. Just want to get the I think we're in the wrong volume. Get to the right volume. Go to the volume, number 5, volumes 13 to 24, and you go to page PDF 929, 929, 929. So then, in the affidavit before court, there's the investigation by Mr. White. During the investigation, the public protector was made aware that Mr. Keletso Manyeki, a former SARS employee, had filed a complaint against SARS to the Public Protector in February 2012. His complaint related to, amongst others, the existence and recruitment of members and operations. Go down. And then it says that Mr. Pillay had provided a comprehensive response. I had taken you to that earlier on. Go down. Paragraph 123 of his affidavit in response to the Section 79 notice issued to him, Mr. Pillay attests that upon the receipt of his response, the former Public Protector informed SARS that she would consider the response and she would revert. There was no further communication. Go down. Then he deals with it. And then he says in paragraph 27.4, the establishment of the unit had been investigated by both the National Prosecuting Authority and the Directorate of Priority Crimes Investigation. And at that stage, despite the lengthy investigation and considerable expenditure, no one had to date been charged for the establishment of the unit. And then they say this must be viewed in conjunction with the recanted findings of both the Kroon Advisory Panel and the KPMG report. Go down. Both having renounced the initial statements that the unit was unlawful and publicly apologized to those affected. And then they say it is evident that these facts were ignored by the Public Protector, since they do not appear in the record, and that the entire legal reasoning is based on the opinion of the Sikhakhane panel on the lawfulness of the establishment of the SARS investigative unit, which is widely considered to be incorrect. Then go back to the document that we were on. It stated that the allegations of the Public Protector relied entirely on the opinion of the Sikhakhane panel is not borne out by the facts. The report of the Public Protector had regard to a number of opinions, including those of Mr. Godan, who sought to persuade the Public Protector that there was nothing wrong with establishing a spying unit within SARS. The Public Protector found the Sikhakhane panel opinion persuasive and exercised their independent views on the true legal position. The narrative that the Sikhakhane panel report is widely considered to be incorrect is not binding on the Public Protector. It is in any way not correct that the Sikhakhane panel report is widely considered to be incorrect. Mr. Godan and those implicated in the report do not like the conclusion of the Sikhakhane panel report. The fact that they do not like the conclusions of the Sikhakhane panel report does not make it widely regarded as being incorrect. Go down. Further, the Public Protector was not bound by the Nugent findings. In fact, the Nugent Commission did not make conclusive findings that the establishment of the spying unit was permitted by law. The evidence of Judge Kroon was not binding on the Public Protector, and given his flip-flopping attitude on the issue, the Public Protector was correct to place no reliance on Judge Kroon. There is no evidence to support the allegation that the Public Protector did not consider legal opinions and unnamed forensic reports. The report lists the documents that the Public Protector considered for purposes of lawfulness, for purposes of the investigation. The Sikhakhane panel report made findings on the lawfulness of the spying unit within SARS that made sense. The Public Protector, however, exercised independent reasoning on the matter, which aligned with that of Sikhakhane. And then she basically again says that Nugent Commission was not binding. Mr. Godan does not identify the evidence in the Nugent Commission that was necessary for the PP to have regard to. The Nugent Commission's mandate is not the same as the Public Protector. And the Nugent Commission was established by the President, who determined its terms of reference. The terms of reference for the Public Protector is the Constitution, whilst that of the Nugent Commission is the President. And hence the Public Protector should not be bound by the findings or evidence of the Nugent Commission. And then it sets out its view on what the interim report is about. And then refers to what the Nugent Commission has said on the findings, which I've taken you to already. Go down. And so it deals with what comparison between the status of a leading senior counsel and a retired judge. In any event, even if the Nugent Commission was not prepared to give the spying unit a clean bill of health, insofar as that related to its activities, the Nugent Commission leaves open the question whether the spying unit was involved in illegal activities. The Public Protector did not leave that question unanswered. The OIGI also made a definitive finding on the illegal activities that the spying unit was involved in. In the final Nugent Commission, it says the lawfulness of the spying unit was not definitively settled with reference to a legal analysis. On the lawfulness of the spying unit, the Nugent Commission said the following remarks. And it then deals with paragraph 9, which I had read earlier. This view does not definitively answer the question of whether SARS was entitled to establish the spying unit in question. The effort is made by the Nugent Commission to analyze any provisions of the law, including the Constitution and the National Strategic Intelligence Act, to reach a definitive finding on whether SARS is entitled to establish the spying unit. The Nugent Commission's opinion was not definitive on the question in this regard. So, and it then says that its comment was simply what it had stated, that there was nothing in the report to persuade it why the Sikhakhane report was not good. Go down. There's nothing in this paragraph that helps to understand the Nugent Commission's reasoning for disagreeing with Advocate Sikhakhane. He makes no reference to the content of the panel's findings and opinions and how it reasoned its way to the conclusion on the lawfulness of the spying unit. There's nothing but unsubstantiated views of the Nugent Commission that could assist an independent assessment of the true legal position relating to the establishment of the spying unit in its recommendations. Deals with governance issues, and it says, more importantly, the Nugent Commission made no recommendations to re-establish the spying unit, which the OIGI had found to be established illegally. It makes no recommendation with reference to the law, how that unit should be re-established, and leaves it as a broad recommendation. The allegation that the Public Protector could have learned something useful for analysis of the law from the Nugent Commission report is belied by the contents of the report itself. It provides no analysis of the law that could have assisted the Public Protector at her work, constitutional work. Okay, but then repeats the allegations in respect of the Nugent Commission, and it goes further and says the Public Protector and the OIG did not, as statutory body involved in investigating the activities of intelligence organizations, the OIGI's report must be believed than the Nugent Commission. The Public Protector was entitled to believe and rely on the findings made by an appropriate body to the constitutional mandate to oversee the work of intelligence agencies as set out in the report of the IGI. Mr. Pillay then, in his founding affidavit, submitted that the Sikhakhane panel report was fatally flawed, and he then refers to a number of documents which says this out, and those allegations are not dealt with from that paragraph onwards in the report in the Public Protector's affidavit. So these allegations in Mr. Pillay's founding affidavit are not disputed in any answering papers. Go on. Right. And he deals with allegations about the Kruan apology paragraph in the Nugent inquiry. Go down. He says it again. And he makes the point on affidavit that the Crown Advisory Board then concluded that it was indeed wrong to have concluded this. I informed the Public Protector that these facts can be determined from retired Judge Croon and the members of the board directly. Then referred to the public records that existed, that set out in detail the legality of the unit. He then deals with the Sikhakhane panel's paragraph that explains how they expanded their mandate and had not interviewed Mr. van Lochenberg. We've dealt with that. Mr. Pillay confirms again that he didn't institute the Sikhakhane panel to investigate a rogue unit, and that persons, multiple persons had not been given a hearing. Go down. Then he says, not only do I take issue with this factually flawed and contradictory nature of the content of the Sikhakhane panel report as set out in my critique, but also with what the report ignores and omits in this regard. And then he sets out what I've already read to you as having been contained in his previous affidavit, that which had been ignored, allegations vis-a-vis Preker, what the attorney had said. Go down. And he says that his critique was not dealt with by the Public Protector. And then he points out that the report had been challenged by Mr. van Lochenberg in the public domain, and that the Public Protector had no regard to it in the notice. Go down. He then makes certain allegations that it's irrational and ill-placed. And he repeats his allegations that Ms. Walters had pointed out significant and fatal flaws in the Sikhakhane panel report under oath before the High Court in another matter, and that the allegation again changed with the introduction of vague and unexplained findings that the unit was unlawfully established, and that it had scant regard to the Sikhakhane panel. Go down. He then quotes what he had previously stated about the aborted negotiations with the NIA. And then he points out to what the Sikhakhane panel said in respect of that. Go down. We've already dealt with that. I read those paragraphs out to you earlier. Right. And the Public Protector then sought to rely on selective extracts of the discredited and contentious panel report, which I already addressed in his affidavit. And then he points out that during September 2014, Mr. van Lochenberg placed the Sikhakhane panel in possession of direct allegations and evidence in support of threats to SARS, demonstrating various attacks on SARS as an institution and undermining its officials. This was never mentioned in the report. Mr. van Lochenberg was never afforded a hearing before the panel or a right to reply. And we know that before the Public Protector, Mr. van Lochenberg also was not consulted. Chair, it's 1 o'clock. Should we, if we come back, it's a convenient place to stop, and then I will deal with what the court judgment says about the Sikhakhane report against the background of the evidence.
Thank you. Thank you, Edward Bauer. Yes, so we'll pause for lunch and take 45 minutes for lunch. We'll be back after 45 minutes, 1:45. Thank you.
Recording stopped.
we're going to proceed with Advocate Bauer. Over to you.
Thank you, Chair. I want to go to the judgment at page 89 of the judgment. Paragraph 89. Right. And it basically says, in the executive summary of the report, it is recorded that Minister Gordhan, during his tenure as the former Commissioner of SARS, established an intelligence unit in violation of South African prescripts. Reliance for this conclusion is specifically made with reference to the fact that the intelligence unit was confirmed by a SARS investigation report compiled by Advocate Sikhakhane. The panel in the Sikhakhane investigation concluded that the unit was established unlawfully, primarily on the basis that it was in breach of Section 3 of the NSI Act. And then what the court does is go down. There is an amendment to the Act, and it looks at the provision that would have been applicable at the time prior to the amendment. So in other words, at the time when the unit was alleged to have been established. And it basically says, if any law expressly or by implication requires any Department of State other than the NIA or SASS to perform any function with regard to the security of the Republic or the combating of any threat to the security of the Republic, such law shall be deemed to empower such department to gather departmental intelligence and to evaluate, correlate, and interpret such intelligence for the purpose of discharging such function, provided that such Department of State shall not gather departmental intelligence with the Republic in a covert manner. And the court, in interpreting the law, and this is one of the areas in which we will argue the court's judgments are in binding, so when they interpret the laws. From a reading of the section, we are not persuaded that the unit contravened the provisions of the NSI Act for the following reasons. Section 3.1 did not impose a general prohibition on the gathering of intelligence. The prohibition only applied to those departments of the state that were required by law to perform functions with regard to the security of the Republic or the combating of any threat to the security of the Republic. SARS was not such a department and was not required by law to perform any functions with regard to state security. SARS was therefore not subject to the prohibition in Section 3.1. Secondly, Section 3.1 did not prohibit all covert intelligence gathering. It only prohibited the gathering of departmental intelligence in a covert manner. Departmental intelligence is defined in Section 1 of the NSI Act as intelligence about any threat or potential threat to the national security and stability of the Republic. The unit housed in SARS was never engaged in the gathering of intelligence of this kind, and its activities fell well beyond the scope of the prohibition contained in Section 3.1 of the NSI, because it was not in the business of gathering intelligence about threats or potential threats to the national security and stability of the Republic. The findings identified in the Sikhakhane report and the panel's interpretation of Section 3.1 of the NSI Act has since its publication been widely repudiated. Judge Nugent, who chaired the commission in 2018, criticized the view of the Sikhakhane report, namely that the unit was considered to be unlawful and stated, and then the same paragraphs of the Nugent report is there, and in specifically paragraph 9, which we looked at earlier, Judge Nugent sets out why, whilst the National Strategic Intelligence Act prohibits the covert gathering of certain intelligence, that applies to intelligence concerning threats to the safety of the state, which hardly applies to intelligence relevant to collecting tax. So Judge Nugent is on all fours with what the full bench is now saying. In this regard, Judge Nugent referred to the legal opinion furnished by Tringrove and Numelo on 1 September 2015 to the former Commissioner of SARS, and then the same list of items to which I referred earlier is set out in paragraph 93. Go down. down. Judge Nugent, with reference to the legal opinion and the Sikhakhane report, as well as the SARS advisory report chaired by Judge Kroon, concluded as follows regarding the lawfulness of the establishment of the unit. And then it quotes what he said in paragraph 11. The public protector inexplicably ignored the report of Nugent Commission in reaching her conclusions. The public protector simply ignored the apology and redaction of the adoption of the Sikhakhane panel's finding of the SARS advisory report headed by retired Judge Frank Cohen, and also referred to by Judge Nugent in the excerpts quoted above. And then it refers to a court judgment where the court was likewise critical of the view adopted by the Sikhakhane report with reference to the Nugent Commission. Quoting further from the Nugent Commission report, saying that there was an onslaught upon those who managed SARS upon allegations once peddled to the Sunday Times to a beguiled public, and it quotes paragraph 28, to which we're already gone to. Go down. And then it says the Sikhakhane report had dire consequences not only for existing activities at SARS, but also for those officials implicated by the report. Following this report, Mr. Muyani, the then Commissioner of SARS, removed several SARS officials from their positions. On behalf of Minister Kudani, it was submitted that the report had the effect of cutting SARS enforcement capabilities, and that it undermined SARS capabilities to ensure tax compliance by prominent politicians and underworld figures, and thus had the result of enabling in a large part the capture of SARS. It is clear from a careful reading of the Sikhakhane report that the authors deviated from the terms of reference, made factual findings about allegations concerning the so-called rogue unit without affording any opportunity to those implicated in the report. The Sikhakhane report also relied upon and entertained allegations made by the Sunday Times newspaper, which the Sunday Times later repudiated, admitted it was reporting fake news, and which it then subsequently apologized to those that it had basically pillared and defamed, including Minister Kudani and Pillay. There is no indication from the report that the public protector considered the public apology published in the Sunday Times regarding its role, postulating what became the rogue unit narrative. In fact, the public protector, during a public interview on 31 January 2019 with Advocate J. Governor of the OIGI, referred to the unit as the rogue unit and as a monster. She also publicly expressed a desire to defeat the monster. These comments unfortunately do little to allay the applicant's allegation that the public protector is biased, or at least subject to a reasonable perception of bias. We come back to this issue later in the judgment to do that. And so those are the parts of the judgment. And then go to paragraph 100, which deals with the act. The public protector stubborn reliance on an erroneous interpretation of section 3(1) of the NSI Act is not explained in the report. She does not engage with any of the legal arguments that are contrary to those expressed in the complaints and her own. At the very least, it was expected that the public protector would critically engage with views contrary to hers, instead of simply repeating the conclusions reached in the Sikhakhane report in respect of the lawfulness of the unit. But in addition to the fact that the Sikhakhane report had been widely discredited, we can likewise find no factual or legal basis upon which it can be concluded that the establishment of the unit was unlawful. In as far as the public protector has placed any reliance on the contravention of section 3(1) of the NSI Act, in arriving at the finding that the unit was unlawfully established, the conclusions are clearly wrong in law, irrational and unlawful. The public protector also concluded that the unit was established in violation of the Act because it was set up without involvement of the NIA. But this is equally wrong in law. The NIA was not legally required to be involved in the establishment of the unit. The public protector's conclusion in respect of the apparent lack of involvement of the NIA in the establishment of the unit are therefore wrong in law, irrational and unlawful. The public protector in addition argues that in the report that the establishment of the unit is improper and in violation of section 209 of the Constitution, and therefore amounts to maladministration under the Constitution and an abuse of power. The court found that the interpretation of section 209 of the Constitution is wrong in law and does not constitute a legal basis for a conclusion. On a plain reading of Section 209, it is clear that this section does not deal with the establishment of COVID information gathering units at all. Section 209(1) reads as follows. Any intelligence service other than an intelligence division of the Defence Force or Police Service. So if we take that section out, it says any intelligence service may be established only by the President as head of the National Executive and only in terms of national legislation. The court said this section regulates the establishment of intelligence services and is confined to the establishment of intelligence services dedicated to the protection of national security. It was, as already pointed out, never the aim of the unit to protect national security. The unit in any event was never an intelligence service in the first place. The focus of the unit was to investigate tax evasion, illicit trade, and organized crime with tax implications. The Public Protector's finding that Minister Mkhwebane had acted improperly and in violation of Section 209 of the Constitution, and that his conduct consequently amounted to maladministration, and in terms of Section 182(1) of the Constitution, and an abuse of power in terms of Section 4(2) of the Public Protector Act is therefore not only wrong in law, but irrational and false to be reviewed and set aside. Shepo, just go back up to the quotation of the Act. The NSI Act, the 2013 Act. Paragraph 90. So the reason I'm taking you back to the Act, because it shows in the Act where the issue of national security comes about. And you see the Act very clearly says if any law expressly or by implication requires any Department of State other than the NIA or SSA to perform any function with regard to the security of the Republic. And so that's where the court's interpretation come into, that it's involved with national security. If we then go to paragraph 205. Public Protector's flawed reasoning goes even further. Public Protector starts off on the premise that the unit was engaged in illegal intelligence gathering, namely spying, wiretapping, generally doing the things that only an intelligence service such as the NIA SSA was lawfully entitled to do. She finds that the unit was illegal from the outset by adopting a legally flawed finding of the Sikhakhane panel. Because the unit was illegally conceived, Sikhakhane panel said so, must have procured and used illegal clandestine equipment in the course of its illegal activities. That's the next step. But the court then says, but even the Sikhakhane report did not find equipment for wiretapping and interception. At paragraph 82 of this report, it was found that, however, as a general rule, it was accepted that the unit did not have the required equipment to carry out such electronic surveillance or interceptions. If you go to 215. Public Protector dismisses the denial of Mr. Mkhwebane on the basis that it is improbable that he could not have known about an illegal unit, and relies on the Sikhakhane report and the Jean Revel report that confirmed the participation of Minister Mkhwebane in the recruitment of employees. Apart from the fact, as already pointed out, that any reliance on the discredited Sikhakhane report is irrational. The public protector on the one hand relies on Mr. Ravel's evidence when it supports her findings on the employment issue, but on the other hand states that his evidence before the Nugent Commission in relation to the lawfulness of the unit, which does not support her findings, was irrelevant and not binding on her. This is a clear example of the public protector's fallacious approach to the evidence and is indicative of the mindset with which she approached the investigation. Go to paragraph 290. But let me just read it. It's a quick paragraph. One of the conclusions that the court reaches and takes into account, and it contributes, it's 290, in respect of its conclusion that the public protector could only have come to such conclusions because she was biased, is the reliance on the discredited KPMG report, despite it having been disavowed, and the Sikhakhane report, despite it having been widely discredited. She also failed to engage with the findings made in the Nugent report. And that's at number 3 that you see that. And there's a list of 9 items on that list of bias that we will deal with at different times to show the committee what the affidavits say and what the court says. We then turn to the issue of the Kroon apology. Shep will go back to the affidavit in response to the subpoena at page, it starts at 216 on volume 3. Yeah, actually I want to go to go to page 234. It's the Pillay affidavit in volume 3, number 4. Now, just go down. Just click on the bookmarks quickly. Go down to volume 3. In volume 3, PG 10 at the bottom. Right, so these 216 in the document. So go to paragraph 23, page 232. Yeah. So you see at 31.7.8, they refer to the apology which was recorded in Judge Nugent's testimony, to which I showed you earlier. And then if you go to, apart from the apology that was rendered, if you go to 31.7.10, is Mr. Pillay's submission about a subsequent admission by the retired Judge Kroon under oath in March 2019 that all the members of the so-called Kroon Advisory Board had deliberated the statement between May to June 2015, that the unit was unlawfully established as put forward by the so-called Sikhakhane panel, and that the board had then concluded that it was indeed wrong to have concluded this. And he says to the public protector, these facts can be determined from retired Judge Kroon and the members of the board directly. Now, when we deal with closing argument, or when we question the public protector, we know that the mail and guardian route was not followed in respect of the Kodan investigation, because we've had the evidence of Ms. Mvuyana in that regard. And we would need to confirm that indeed this was not followed up on. Right. If we look at the public protector's affidavit in response to the section 79, you will see that these are repeated if you go to page 318. Now, but now you've got to go to the next document. Just go to the bookmark. Right, and you go to click on PG 10 in volume 4. It's 301. You must go to 324. Right, so if you see that again in his affidavit, Mr. Pillay says the same thing. He refers to the testimony of Judge Kroon, the apologies rendered by Judge Kroon, and then 90.4, he refers to what he calls the entire board's reconsidering the notion that the unit was unlawfully established. To do that. And then if you go to PDF 517, if you go further down to 126.1.3, first looks at the Sikhakhane report, and he then goes to the KPMG part, he goes to the Kroon part, and he says it again there in doing it. All right. And if you look at what he said at page 624, and if you go down the page to down on the page, hold on, we've messed it up now. Go back to volume 11. Yeah. PG 31. And that is the affidavit in which Minister Kodan responds to the section 79 notice served on him. Yep. Right. And if you go down to paragraph 43.2, you will see that Minister Kodan in the same way says to the Public Protector that the SARS Advisory Board chaired by Judge Kroon, who also initially endorsed the Sikhakhane conclusion at the time, Judge Kroon, however, recently recanted this endorsement in his evidence before the Nugent Commission. He conceded that there was no reason to contend that the unit had been unlawfully established. He had apologized, and he refers to media reports. He then, whilst we're there, you might as well just look at the next. He too refers to the Nugent Commission in paragraph 11 of that report. And then he concludes at paragraph 44. The Public Protector does not engage at all with any of these views, which are contrary to her own. She simply ignores them and makes a contrary finding for no cognizable reason. In other words, why is she right and they are wrong? the inference is irresistible that she is willfully blinded by a determination to make an adverse finding, regardless of verifiable facts. We know that if you go to 256, which would be in the Public Protector's report, paragraph 5.25 is the only reference to Kroon, right? And in doing that, it is the quotation that is taken from the Nugent Commission report. And if you go further up, 5, 10, and 11, you will see that it is quoted from the SARS response that is handed in. So it's not part of the evaluation of evidence, it's part of the submissions that come from SARS. And then if you go back to the document we were on, and let's see what the litigation had to say about the I think it's page 37. The evidence from different reports. So go down, further down. Got to go past all of that. Just click on page 37. Right. So we go back to the affidavits we looked at under Part A, and we again see that in respect of the Kroon affirmance, the Public Protector, go further down. The affidavit said that she would not be dealing with these allegations as part of Part A. So and we see the allegations made at paragraph 57, 97, sorry, that the advisory board chaired had initially endorsed the legally flawed interpretation, that Judge Kroon recanted this endorsement in his evidence for the Nugent Commission, and he conceded there was no reason to do that. So that he said before the court, and then the apology is detailed in paragraph 99. And if you go across the column, then you see in paragraph 16, Mr. Pillay refers to the affidavits that he had filed in the matter in which he raised that. And if you go down, you see that he confirms truth of his affidavits in every respect, and he stands by the contentions of law set out therein, and he would amplify that in due regard. So now we come to Part B. And we see that in respect of 86, see in the reply, Minister Gordhan, we have already looked at the same averments earlier on in respect of the Public Protector's answering affidavit. In reply, Minister Gordhan says it is unclear how she could deem it unnecessary to interview both Mr. Ravel and Judge Kroon when there were two key witnesses at the Nugent Commission on this very issue. And that's a response if you go down. That was the point taken the Public Protector simply denies that the SARS advisory panel endorsed a legally flawed interpretation, and she expresses great concern that the judge would behave as Judge Kroon did, and the circumstances that forced him to recant are not yet known. It doesn't appear she made any, as if there was an endeavor to interview Judge Kroon in any way. If we go to paragraph 101, the public protector simply repeats the avermances there that she's not bound by the findings of the Nugent Commission or the recanted position of Judge Kroon. When it comes to the supplementary affidavit, the point is taken, this must be viewed in conjunction with the recanted findings of both the Kroon Advisory Panel and the KPMG report. Both bodies have renounced the initial statements and the unit was unlawful and have publicly apologized to those affected. Public Protector says, to my knowledge, it is only just Judge Kroon who recanted. It was his view and not that of the panel. I'm not aware of the panel having accepted the Kroon position on the findings of the advisory panel. The record does not, the minister says the record does not contain any evidence that the Public Protector took steps to interview Mr. Ravel and Judge Kroon or assess the evidence in full against, as given again before the Nugent Commission. And the answer is, it is presumptuous to suggest that the Public Protector did not take steps to verify the authenticity of the documents that she relied on. Mr. Godin provides no evidence of any documents that turned out to be, I think, probably means not authentic. His view that I should have considered newspaper articles and media commentaries and private individuals to perform my functions cannot be taken seriously. To the contrary, the Public Protector verified the documents that she considered, according them the weight necessary to come to the findings and conclusions that she came to. There was no need to interview Mr. Ravel and Judge Kroon for the purposes of deciding on the lawfulness of establishing a spying unit within SARS. And then I've already pointed out that in respect of the Pillay founding affidavit, the allegations that followed were not responded to. And if you go to further down, paragraph, go down, stop there, yeah, there we go. Subsequent admission by Judge Kroon under oath, and then it records that the Kroon Advisory Board had deliberated the statement between May to June 2015 that the unit was unlawfully established as put forward by the so-called Sikhakhane panel. And that allegation is not disputed on the affidavit before the court. And then the allegations that followed repeat very much the ones that have appeared in the previous affidavits. With respect to the apology, go right down, Shepo. And you see, if you go down to the bottom, in 96.4, same averment is made again, and it's not challenged. And then in paragraph 108.5, it recorded what the board had previously done, etc. And if you go to the judgment, I think I've encapsulated, just stay there, the 2 paragraphs of the judge, 3 paragraphs of the judgment are there. This is what the court said. The Public Protector inexplicably ignored the report of the Nugent Commission in reaching her conclusions. The Public Protector similarly ignored the apology and the retraction of the adoption of the Sikhakhane panel's finding by the SARS Advisory Board headed by retired Judge Frank Kroon, and also referred to by Judge Nugent in the excerpt quoted. Mr. Pillay submitted in particular the Sikhakhane panel, the Kroon Advisory Board, the KPMG process. The process is conducted by advocates Martin Prassi, Nadine Fourie, and Mike van Assen, and attorneys Mashiana, Moodley, and Munama, as well as multiple investigations conducted by the Hawks and NPA since 2014 to date, as well as the OIG report, have all fallen victim to the perpetuation of the false rogue unit narrative to some extent or another. He submitted that this is particularly so because they all, as a rule, fail to hear those they pronounce upon meaningfully at all, fail to provide any right to reply before making conclusions, findings, recommendations, and cherry-pick the twisted little truths mixed with a great deal of fiction. At 184, the court concluded the public protector had further failed to reflect on material and relevant events, facts, and evidence relating to the Kroon Advisory Board. Mr. Pillay particularly referred to the testimony by Judge Kroon before the Nugent Commission, which specifically impacted on the intended or provisional findings in the notice. He referred to the formal apology that had been rendered, and the public protector had concluded that the public protector failed to consider the fact that some after 28 April 2015 for the period May to June 2015, the entire board reconsidered the notion that the unit was unlawfully established and concluded that they should not have made this finding after all, but never informed the public. That was undisputed on the papers before the court, as I showed you earlier on. And so the court concludes at 289, we conclude that taking into account the following, a conclusion of bias is warranted. The public protector completely disregard of the Sunday apology and the Kroon apology. So we turn to the KPMG and we go back, Shepherd, go back to the second 216, go to page. G10. Volumes, yeah, 3. So it's number 4 still. Yeah. Just want to go to paragraph 24 of the document. Go up. Up to 24. Right. So this is again, we back at Mr. Pillay's affidavit in response to the subpoena. Let me just, yeah. No, sorry, Shepherd, just go up to the top. Let me just make sure which affidavit we don't want to, yeah, don't want to misrepresent. That's what I thought. So what we're looking at is to paragraph 24. This is the response to the section 7(9) notice. Right. And in paragraph 24, you see that the public, what Mr. Pillay does is he records that for purposes of the section 7(9) notice, the public protector claims to have relied on and considered the following evidence. Information and documents provided by whistleblowers and the complainants. And the point is taken, but the notice does not reflect on the evidentiary value, authenticity, accuracy, or context of these materials. Right? Documents previously provided by SARS, which are not fully identified or listed. Undated and unidentified document that is provided at 14.2.19 of the notice. An undated and undescribed document entitled Jean Revel dossier, which Mr. Pillay says he wasn't provided with. An undated and undescribed submission as set out in paragraph 14.4.27. undescribed purported evidence pertaining to an application to an internal position in SARS by Mr. van Lochenberg on 13 January 1999, almost 20 years ago. A memorandum of understanding between SARS and the National Intelligence Agency dated 2002. Confirmation by the IGI dated 31/2019 of the existence of a unit at SARS and that it was investigated by the IGI as contained in a report dated 31 October 2004, of which the Public Protector is seeking a copy. I record in this regard that this report has never been provided to me and I never participated in the process as an interviewee. The SARS Recruitment and Selection Policy 2007, internal SARS emails, some SARS memorandum. Submission to the Minister of Intelligence, some more SARS memorandum, undescribed purported evidence pertaining to an application by Mr. van Lochenberg on 2007, undescribed further evidence 2008, an informal SARS document which the Public Protector claims to be dated 14th May entitled Rules of Play. And the correct date was 11th April. The SARS Bid Adjudication Committee minutes, 23 February 2009, procurement request by ICAS, cabinet approval dated 15th April, a SARS letter dated 8th May, internal SARS transfer, a procurement request by the SARS CAS division, a complaint by Mr. Busisiwe Mkhwebane dated 2004, in which he claims to have been a member of SARS Customs Border Control Unit, as well as the SPU NRG HRI. A 5 May 2014 procurement request by ICAS, a SARS memoranda, a SARS response to the previous Public Protector under Mr. Pillay's hands dated 26 August. And that is the document which Mr. Pillay referred to previously as being the comprehensive response which he had submitted to Advocate Madonsela. And then he notes that the Public Protector does not refer to the reply they took. The 25th September 2014 procurement request by ICAS, further bid adjudication documents, and then he says the Sikhakhane report. And then he says he provided the Public Protector his legal critique dated December 2014, which had not been referred to, disputed, or even mentioned in the notice. A KPMG report dated 4 December 2015 that had not been provided to him to date. Another KPMG report that had not been provided to him to date. A procurement request by ICAS. Go down. Right. And then he lists further documents, interviews, and in 2439, you see that there's an alleged recording between the former SARS Commissioner Tom Moyane and Andries Jansen van Reenburg, which is undated, which Mr. Pillay says he's never been provided with. A recording with Mr. Moyane and Messieurs Albert Lombard and Johan de Waal, which is undated. An undated submission to the Public Protector by Mr. Mkhwebane, and then an affidavit by Mr. Magashula, affidavit by Mr. Pillay, an affidavit by Mr. Godan. And then Mr. Pillay says, in regard to the evidence in inverted commas relied on by the Public Protector for findings, I reiterate what he had previously stated, which I had taken you to earlier on about the difference between evidence and information. The process adopted by the Public Protector, which involves me having to defend myself against what may or may not emerge out of this evidence without any opportunity whatsoever to consider, contextualize, or challenge it, is the epitome of unfairness. And I want to take you to paragraph 73 of the affidavit. We've gone past. Right. This is where, again, there is mention to the KPMG South Africa and the Judge Frank Kroon, who have both later effectively repudiated the findings. None have ever responded to the factual, procedural, and legal flaws in their work, nor the refusal of due process and the basic principle of ade alteram partem of those they pronounced upon in order to defend their work funded by taxpayers. Many involved in these processes have remained silent in the face of legitimate questions about their roles and participations and work at the time. And then he says it was at this time that state capture of state institutions were in full swing. Go to paragraph 85. The reliance on the so-called KPMG report is irrational and in place. This is because it was admitted by KPMG South Africa to be a mere documentary review, which included limitations. Neither I nor anybody else implicated was afforded a hearing or right to reply. The report has been contested as profoundly flawed in fact and in law in many ways by many people in many platforms, amongst others with KPMG South Africa, SARS and Parliament. The report contains a disclaimer of a nature that states it can neither be referred to nor used in any dispute or controversy. Findings, conclusions, and recommendations have been formally withdrawn. KPMG's head of forensics, Mr. Roy Waligora, has testified before Parliament and under oath before a panel instituted by the South African Institute of Chartered Accountants that the person who compiled the report was lazy and unprofessional, and the report was influenced by outside parties and a result of copy-paste work. The complete fee for services rendered to SARS of an amount of 23 million was repaid to SARS, effectively repudiated the entire report. KPMG South Africa and KPMG International on their behalf have publicly apologized to South Africa, entirely stating sorry, and we know sorry will never be enough. I, among others, have privately received an apology from KPMG South Africa in this regard. The report has no value whatsoever. And then he says, furthermore, I place the following on record in regard to the KPMG report. The KPMG report seems, for reasons unknown to me, to only reflect upon me, Messrs. Richer, Yolisa Piki, Van Lochenberg, and the unit described as the subjects of the investigation. For some further unknown reason, the now withdrawn findings and recommendations also sought to drag former Finance Minister Mr. Pravin Gordhan into the fray. One version of the report, again for unknown reasons, also appears to have sought to implicate former Minister of Intelligence Mr. Ronnie Castles. What exactly informed the specific focus on these particular individuals and the scope and terms of reference are unknown to me. In essence, the KPMG report contains significant and material factual errors, omits material and relevant facts, makes misrepresentation of facts, makes facile comments and statements, shoehorns information to suit the narrative of a rogue unit, conceals or omits evidence and facts of serious criminality, seeks to rely on Kanyana and Sikhakhane panel reports, but fails to reflect on their factual inaccuracies, contradictions, omissions, and flaws, instead seeking to rely on selective aspects thereof. It is unfair and untruthful and lacks integrity, uses loose language and makes flawed assumptions that are unsubstantiated and unsupported by any evidence, in some cases false and defamatory and or wrongly attributed, cases using sweeping phrases such as it may be, could be, possibly, we understand to be, may have, there is reason to believe, and so forth. Ignored exculpatory facts and evidence, ignored publicly available facts and evidence that contradicts the content, ignored basic facts which could have easily been obtained and which are material to the topics it expresses views on, and followed a legally questionable process to compile and publish the report. Further, I also specifically refer to the obligation which rested on KPMG South Africa to report evidence in terms of Section 34 of the Prevention and Combating of Corrupt Activities Act, and the failure to do so being a criminal offence KPMG not only failed to adhere to this, but in my view, concealed evidence and ignored it deliberately. And then it says KPMG did not declare the patent conflicts of interest in relation to the role of Ms. Belinda Walter as service provider to them, both as attorney for Stein, Kenya Inc. and later in 2013 as Belinda Walter attorneys, nor a role as a secret agent for British American Tobacco, of which KPMG is the external auditor, and in as much as this was most relevant to their brief. The report ignores the basic tenets of natural justice, the fundamental right of reply before being judged, and does not reflect on the views and the responses of those that pronounce judgments upon. I was always maintained and stated so in writing that KPMG South Africa heard me and others they pronounced upon they would not have made the adverse comments that they did. As with the Sikhakhane panel process, I do not only take issue with the content of the report, but also with what is not contained in the report. Even at the most basic level of simple facts, the report is factually wrong. It does not reflect upon material and exculpatory facts and acts of serious criminality, the disruption of state institutions and actions, and the manipulation of state officials and their officers. I'm astounded as to how the allegations kept on morphing over time and how these were not dealt with by KPMG. The initial allegations against the SARS unit, which commenced in the media from 12 October 2014 onwards, were that they had broken into homes, conducted house infiltrations, broken into President Zuma's home, planted listening devices there, were involved in the deaths of former SARS officials, used secret funds of over 560 million, bought new homes and cars, conducted lifestyle audits on prominent politicians, infiltrated politicians as bodyguards, spied on top cops and the late former National Police Commissioner Jackie Selebi, spied on President Zuma and another at the Beverly Hills Hotel in Durban, entered into dodgy settlements with taxpayers, wanted to swing elections, owned and used a so-called grabber, operated a brothel as a front, used a fundraising initiative for charities as a front, operated front companies, were deployed to destroy careers of SARS officials, purchased sophisticated spying software, and used this intercepted taxpayers' telecommunications and emails and so forth. I find it no coincidence that the report failed to reflect on most of these allegations in any meaningful way. Instead, only a few of these allegations are briefly mentioned and not properly dealt with. Loose language again is used to refer to some aspects only, but none are dealt with in the manner one would expect of a firm such as KPMG. The report introduces concepts foreign to me, such as a virtual unit and unit by association. These are simply figments of a creative imagination. I believe it would have been reasonable to expect of KPMG in a process of which cost the taxpayer 23 million with such serious consequences to act independently, fair and with integrity, to list all of the allegations and then reflect upon each and every one, either confirming them or disproving them or expressing some sort of definitive view on them. Those not confirmed should then cause KPMG to reflect upon what exactly led to these being bandied about with wanton abandon in the media. It begs the question, if none of these allegations are true, who were the people behind these allegations? Why did they leak it to the media? For whose benefit and to what end? The KPMG report is silent on all of this. I believe firmly that the language and style of both the Sikhakhane panel report and the KPMG report, notably the use of loose language, sweeping allegations, and unsubstantiated conclusions and contents, is not dissimilar to the language and style of the notice. From the notice, it is further apparent that the Public Protector had failed to reflect on material and relevant events, facts, and evidence relating to the so-called Crew and Advisory Report in particularly, and then a number are listed thereafter. Go to paragraph 98. Ever when this continually changing allegation and all the others up to this point were found to hold no water, the allegation morphed yet again in an even more vague fashion by way of the leaked KPMG report, which I have already dealt with above. In the KPMG's report, now repudiated and withdrawn, conclusions, findings, and recommendations, the statement was made that the unit was established in contravention with the rule of law, with no legal explanation or setting out as to why this was so. Paragraph 126.1.2 2. The KPMG report is profoundly flawed in fact and law and cannot be relied on for any purpose. Its findings have been repudiated and withdrawn. The full fee is replayed. And then it says, furthermore, its disclaimer as contained in the leaked version renders it useless for the purposes for which the public protector seeks to use it. The disclaimer states in no uncertain terms that the KPMG report may not be provided to any third party, may not be used in draft, may not be used in part, may not be used in final, may not be used in portion thereof, cannot be relied upon for resolution of any dispute, cannot be relied upon for disposition of any dispute, cannot be disclosed in whole, cannot be disclosed in part, cannot be quoted in whole, cannot be quoted in part, cannot be referenced in whole, cannot be referenced in part, cannot be disclosed unless written approval is obtained from KPMG for purposes not described, and was not intended for the express or implied benefit of any third party. Paragraph 143. Mr. Pillay then reiterates, I will already set out why the KPMG report cannot be used for purposes and relied on. And then he repeats all of that. And he doesn't say anything different other than that it's been the many platforms in which it was raised there. And then he reiterates at 1.43.2, he summarizes up the disclaimer, the fact that its findings, conclusions, and recommendations have been withdrawn, that the fees have been returned in 3, and then go to paragraph 163. Then he says that 163.2, KPMG appears to seek to impute or suggest or allege that the specific unit in question acquired and or used sophisticated surveillance equipment. The content of the leaked draft report, however, provides no evidence or substantiation or support for this contention. The heading and the content of the paragraph are incongruent of each other and misleading and deceiving of the reader. It is telling that the finding in a block on page 104 of the draft report leaked to the media states the unit and SARS during the period made inquiries, acquired, and were offered equipment regarded as listed equipment during the period 2006 and 2014. From paragraph 7.11.2 to 7.11.9 on pages 105 to 108, certain equipment is listed and described, but in no instance is there any substance or supporting evidence provided in the report that proves that the unit in question acquired such equipment and used it. KPMG does not say so and does not demonstrate how the equipment was supposed to have been used by the unit. The equipment referred to was most likely that which was acquired by the SARS ACAS, which is a completely different unit. The public protector has not considered purchase orders, order requisitions, asset registers, and proof of payment and signatories to these documents, along with the cost center analysis and determination showing which unit in SARS paid for and controlled the equipment. These documents are easily accessible by the public protector. To the reader of the leaked KPMG report, at first glance, it would seem that the unit in question acquired surveillance equipment. On closer scrutiny, though, the content of the leaked draft of the KPMG report does not state so as a fact. The KPMG report deceitfully uses the term the unit and SARS interchangeably, which is deliberately misleading. KPMG does not state, nor does KPMG emphatically provide evidence of any kind that the unit in question obtained and used surveillance equipment in any manner or for any purpose, let alone unlawfully or illegally so. The reference to and reliance by the public protector in the notice to the statement by KPMG that the possibility cannot be excluded that the equipment and software was available to them is mischievous. no evidence has been provided either by KPMG or the Public Protector to back up this entirely speculative conjecture. He then, with reference to certain further paragraphs, says, the matters recorded in these paragraphs relate to a completely different unit that existed at SARS, and this has got to do with the equipment that had been obtained, and have absolutely nothing to do with the unit in question in any manner or form. To do that. And then at 164.3, he records that none of the equipment in relation to any of the documents listed are capable of interception of communication. All are commercially available and commonly in use by multiple government departments and corporate companies, as well as private investigators, companies, and journalists. The purpose was solely intended to assist the unit overseen by Mr. Clifford Collins, namely the ACAS, to safeguard SARS property, assets, officials, records, facilitate security at ports of entry and warehouses under control of SARS, and conducting anti-corruption investigations within SARS. This has absolutely nothing to do with the then disbanded unit. And Shep will then go back to the judgment. Not the judgment. The affidavit. Now go back to the document that says evidence from different reports. It would be roughly page 53. So scroll down. See the table coming out. So again, as we did before, we looked at the part A of the affidavit in which the allegations were contained, and the references made to the KPMG report and the withdrawal of the report. And the point is made that in the KPMG report stated that neither go down. Neither the SARS Act nor the Tax Administration Act recognize SARS as a law enforcement agency and does not vest its employees with the powers of enforcement officers. And at paragraph 12.1.2, the KPMG report under heading said executive findings and conclusions records that under the guidance of Pillay, covert and rogue intelligence unit in contravention of the rule of law was established by SARS. So again, the approach of the Public Protector is I'm only dealing with allegations relating to Part A. I'm not going to be able to deal with the allegations. I'm not dealing with the allegations relating to the substance of the review in dealing with that. In the replying affidavit from Minister Kudan, there's no mention of KPMG, and we know that Mr. Pillay's affidavit supports the relief sought by Minister Kudan in that regard. So we know if you go down, there's reference and acknowledgement from what KPMG precisely did, and Mr. Pillay dealt with it in these affidavits, effectively putting out the submissions from KPMG to which we referred. And then you see in Annexure PG 15, which is out of place actually because it deals with the Kroon report. I need to put it up. Is the media articles in which it stated that the panel had visited it and discussed it, and it was concluded that we should not have made the statement. If you go down further to the document, you see the KPMG retraction. SARS report refers to legal opinions, illegal conclusions, as if they are opinions of KPMG South Africa. However, providing legal advice and expressing legal opinions was outside the mandate of KPMG South Africa and outside the professional expertise of those working on the engagement. KPMG South Africa acknowledges that such opinions should have been caveated as recommendations of legal advisors are not formulated in the manner contained in the report. Then they say, as a result, it is possible to read certain sections of the executive findings and conclusions contained in the report in a way which suggests that Minister Gordhan knew or ought to have known of the establishment of SARS of an intelligence unit in contravention of the rule of law that was rogue in nature. This was not the intended interpretation of the report. To be clear, the evidence in the documentation provided to KPMG South Africa does not support the interpretation that Mr. Gordhan knew or ought to have known of a rogue unit of this nature, of a rogue nature of this unit. If we then look at what the Public Protector answered to the Gordhan founding affidavit, and you see that in answering to the 3 paragraphs, it says the prevarication of an organization on its work would be unhelpful to anyone serious about pursuing constitutional truths. The KPMG report is irrelevant as a source of Mr. Gordhan's review application. I was not bound by the positions of the KPMG. She acted independently, impartially, with dignity and effectively. All right. So that's the response to 103 to 105. Total. And then if you go to the supplementary founding affidavit, just the next page. Go down. The Public Protector says the KPMG report is irrelevant as the source of Minister Gordhan's review application. I was not bound by the position of KPMG. And then the Minister says the following people and bodies have investigated the same issues, and then points out that KPMG had renounced the initial statements, was unlawful, and have publicly apologized to that effect. And the PP says the KPMG report raises issues that must concern any self-respecting institution of government. To simply accept their recantation without more is scandalous. It is for this reason that the Public Protector was entitled to investigate the complaints about SARS, especially because it appeared that there was a cover-up by forensic investigations. Millions of rands were spent by Justice Kroon and the KPMG to conduct work relevant to the functioning of SARS. Mr. Gordhan does not appear perturbed by the astronomical, financial, and personal resources that were deployed by government to conduct investigations in which those who did so recanted on their findings. The clearest sign that there was a cause for concern to justify the Public Protector's decision to conduct an investigation into the allegations involving SARS is this conduct of the Kroon Advisory Panel and the KPMG. It is simply opportunistic for Mr. Gordhan to rely on the renunciation of these reports as proof that the Public Protector should not have investigated the issues. One would assume that the conduct of the Kroon Advisory Panel and KPMG should not concern anyone, including the Public Protector. Further, in any event, the Public Protector was not bound by conduct apologies of the Kroon Advisory Panel and KPMG. The Public Protector is a constitutional body with a responsibility to the South African public to investigate and report on activities of government bodies, and points out that those bodies have no constitutional mandate at all. Their work could never be binding on the Public Protector, and the suggestion that they could have is naive and irresponsible, coming as they do from a member of cabinet with special constitutional duties. Minister Gordhan says it is evident that these facts were ignored by the Public Protector since they do not appear in the record, and a and that the entire legal reasoning is based on the opinion of the Sikhakhane panel on the lawfulness of the establishment of the SARS investigative unit, which is widely considered to be incorrect. And then the answer is the public protector is not bound by the findings of the current advisory panel, and then that's an abbreviation for the Nugent Commission. The public protector has irrevocable constitutional qualities, which includes independent, performing its duties impartially, and exercising powers and functions without fear, favor, or prejudice. Just to emphasize, those things are then set out again to do that. And then with reference to the Pillay founding affidavit, these allegations were again not responded to. If you go down, you'll see it largely repeats what I've already drawn your attention to and read to you from these affidavits. If you go down, Cheryl, past paragraphs 94 that we've already dealt with. And you go to the judgment at the bottom that says full bench. We've dealt with those averments earlier. The second report relied upon by the public protector is a report compiled by the audit firm KPMG for the erstwhile SARS Commissioner, Mr. Muyani. In the report, the public protector relies on the findings made in the KPMG, particularly with reference to the unit's operations. Reference is made in the report to the fact that the KPMG report has found that there was clear evidence that the unit intercepted private individual communication and that members of the unit were not employed by SARS, but they were recruited outside of SARS, acknowledged systems and processes. Apart from the findings in respect of the activities of the unit, the key finding in the KPMG report is that Minister Gordhan knew or ought to have known not only that the establishment by SARS of an intelligence unit was in contravention of the law, but that the unit was rogue in nature. What the public protector does not record in the report is the fact that on 16 September 2017, long before the public protector delivered the report, KPMG had disavowed its own report and particularly its conclusions regarding the lawfulness of the unit. Not only did KPMG tender an apology for its governance lapses, it refunded the fees it had received for its report. KPMG has since admitted that important quality controls were not performed to the standard of the firm. KPMG also acknowledged that insofar as the report refers to legal opinions and legal conclusions, as if they are the opinions of KPMG South Africa, it was outside the mandate of KPMG South Africa and outside the professional expertise of those working on the engagement. KPMG then concedes that the language used in sections of the report is unclear and results in certain findings being open to more than one interpretation. As a result, it is possible to read certain sections contained in the report in a way that suggests that Pravin Gordhan knew or ought to have known of the establishment by SARS of an intelligence unit in contravention of the law that was rogue in nature. And then it said, this was not the intended interpretation of the report. To be clear, the evidence in the documentation provided to KPMG South Africa does not support the interpretation that Mr. Gordhan knew or ought to have known of the rogue nature of this unit. We recognize and regret the impact that this has had. KPMG South Africa had no political motivation or intent to mislead. Given the failure to appropriately apply our own risk management and quality controls, that part of the report which refers to conclusions, recommendations, and legal opinions should no longer be relied upon. KPMG South Africa has contacted SARS and offered to repay the 23 million fee received for the extensive work performed. So the court says the KPMG report is flawed in fact and in law, and its findings and conclusions have been formally withdrawn. Any reliance by the public protector of the KPMG report was under the circumstances irrational and ill-placed. Mr. Pillay also warned the public protector that any reliance on the KPMG report would be irrational and in place because it was admitted by KPMG South Africa to be a mere documentary review, which included limitations and had no value whatsoever. Mr. Pillay contended that in addition, none of the people implicated in the KPMG report were afforded a hearing or right of reply, and the report had been contested as profoundly flawed in fact and in law in many ways by many people in many platforms, amongst others by KPMG South Africa, SARS and Parliament. Moreover, its findings and conclusions and recommendations have been formally withdrawn. Mr. Pillay stated that he had even privately received an apology from KPMG South Africa in this regard. Mr. Pillay described how the rogue narrative was perpetuated by these reports, while those affected by these reports had never seen them, were never afforded a right to reply, and were banned by former SARS Commissioner Mr. Tom Moyane from defending SARS, its officials, and themselves from this public onslaught. He stated that having read the notice, he was firmly of the view that the public protector was merely advancing the same false rogue unit narrative, and the ever-changing continuing attempt to make something stick to the unit was malicious and capricious and clearly intended to keep the narrative alive for ulterior purposes. The KPMG report appears to suggest that the specific unit in question acquired and or used sophisticated surveillance equipment. Mr. Pillay sets out in his first affidavit while the KPMG report provides no evidence or substantiation for this contention. On closer inspection of the report from paras 711.2 to 711.9, on pages 105 to 58 of the KPMG report, certain equipment is listed and described, but no evidence is provided that it was the unit that acquired such equipment and used it. The reference to and the reliance by the public protector in the notice to the statement by KPMG that the possibility cannot be excluded that the equipment and software was available to them is mischievous. We conclude that taking into account the following, a conclusion of bias is warranted. The reliance on the discredited KPMG report, despite it having been disavowed, and the Sikhakhane report, despite it having been widely discredited, she also failed to engage with the findings made in the Nugent report. Now, we know that the full bench then found against the public protector, and there was then an application for leave to appeal, which was lodged thereafter. And Shepherd, go to the bundle E 8.3. Bundle 8, bundle E, I think. Yep. Right. So this, you will see from page 2. Is that the public protector seeks leave to appeal to the SCA against the whole of the judgment and order handed down by the full bench on 7 December 2020, save for those portions which are favorable to the applicants, including the punitive and personal cost orders. And the parts that's favorable is the application to strike out where the court found in favor of the public protector in relation to utterances made by Minister Godan. If you go to page 15 of the document, and you will know that last week I took you through, actually when I go to paragraph 30, go up, it would be the PDF. Yeah. Right. Last week, we took you through the IGI report, and I haven't taken you through to the judgment yet, but I do want to point to you that in the application for leave to appeal an affidavit, the point that was made to the appeal court, and the only point in relation to the IGI report is the subsequent or ex post facto setting aside of the IGI report is irrelevant to the present proceedings. The court acquires rejection of the submission that the report had not been reviewed at the time of the issuing of the public protector's report as meritless is in the circumstances a gross misdirection. There's no such thing as prophetic mootness. The IGI report had only recently been set aside. At the time it was relied upon, it had not yet been set aside. So we now know from affidavit, the public protector in her affidavit and application for leave to appeal said that the IGI report at the time it was relied upon had not yet been set aside. Right? If you go into the judgment, go to the PDF page 140. And go to paragraph 7. So the bench hears argument on the application for leave to appeal, and it then writes a judgment in which it refuses leave to appeal. And this is what it has to say then. The respondents have not met this threshold, and this is the threshold as the test as to whether you must be granted leave to appeal. Whilst it is right that an application for leave to appeal does not provide the parties with an opportunity to re-argue the matter, it is quite apparent from the heads of argument and submission made by the respondents' counsel that parts of the judgment they seek to appeal against have either been misinterpreted or misunderstood. And I'm going to take you, having covered with you in respect of when we talked about the CR 17 judgment, we spoke about the findings on the Executive Ethics Code in this judgment. We also spoke about the IGI and the costs. So I want to, in one go, take you through what the court said in respect of all of them. So let's go to paragraph 11 first. The manner in which the first respondent is capable of reaching conclusions which are unsupported by the facts and the law, a fact which supports the improper motive and biasness ground of review, is demonstrated when she deals with the applicable Executive Ethics Code in relation to the Ambani meeting. It is an irrefutable fact that the Executive Members Code 2000 does not punish inadvertent mistakes. Yet the first respondent states in the heads of argument that the finding that the applicable code does not punish inadvertent mistakes is incorrect. To start with, that was not the finding of this court as explained above. Yet the first respondent perpetuates this misunderstanding by stating the applicant is cognizant of the fact that unlike the 2000 version, the 2007 version of the Executive Ethics Code, the Executive Code reads thus: members of the executive may not willfully or inadvertently mislead the legislature to which they are accountable. The fact is that there is no 2007 version of the Executive Ethics Code, and this was conceded by counsel who represented the first respondent during the hearing of this matter, Mr. Masuku SC. According to Mr. Masuku, the first respondent had based the findings in this regard on a ministerial handbook. The repetition of the misunderstanding in an application for leave to appeal can only be described as astounding. It bears mentioning that the misunderstanding was the basis on which the first respondent recommended remedial action with potentially far-reaching consequences against Minister Kudan to the President. Go to paragraph 14, which deals with the IGI. In considering the establishment of the SARS unit, the first respondent relied on a number of reports produced by other institutions or public officials, such as the Inspector General of Intelligence. The prevarication and ambivalence of the first respondent regarding that part of the investigation raised serious concerns by the court. She was found to have been dishonest in that she claimed on the one hand that she had not seen the OIG report, but that she had relied on it in crafting the terms of remedial action. Later, she conceded that she was in fact in possession of the classified OIG report. That report has since been set aside entirely. The first and 10th respondents are appealing the court's findings that the first respondent's findings were irrational to the extent that she relied on the OIGI report. Go one page next. It's a little bit out of order. So page 8, yeah. Go down to go past page 8 and you'll find page 7. Yeah. They submit that the first respondent could not have possibly foreseen that the OIG report would subsequently be set aside. The court found inter alia that had the first respondent considered the OIG report properly and applied her mind diligently, as she was called upon to do, she would have established that the OIG report was a flawed document in that it was a product of ultra vires conduct on the part of the Inspector General of Intelligence. It is also common cause that those implicated in the OIGI report would not have afforded a hearing in terms of the Habeas Altrum Partem principle, yet the 10th respondent argues that this issue was merely a factor to be considered by the first respondent in assessing evidence and that it could not be fatal to our own report, and that it was therefore rational for the first respondent to have relied on the OIG report. In considering whether the first respondent had acted rationally regarding reliance on the OIG report, the court referred to the case of Democratic Alliance versus President of the Republic of South Africa, where the Constitutional Court held as follows. The conclusion that the process must also be rational, in that it must be rationally related to the achievement of the purpose for which the power is conferred, is inescapable. An inevitable consequences of the understanding that rationality review is an evaluation of the relationship between means and ends. The means for achieving the purpose for which the power was conferred must include everything that is done to achieve the purpose. Not only the decision employed to achieve the purpose, but go up, no, right? But also everything done in the process of taking that decision constitutes means towards the attainment of the purpose for which the power was conferred. The facts in the OIG report were never tested, in that the affected persons were not granted the audi, and the reliance on those untested facts which constituted the report is irrational. And then on costs, the court ordered the first and second respondents to pay the cost of the applicants on the scale between attorney and client, and limited the personal liability to 15% of the total cost. It was also held that the first respondent had acted in total disregard of the values enshrined in section 181, 1A and 182 of the Constitution, which called upon the first respondent to be impartial and to exercise the powers and perform her functions without fear, favor, or prejudice. The court found that this failure on her part warranted a personal and punitive cost order. The court found that the first respondent acted with blatant dishonesty and biasness, in that she ignored hard facts and evidence, thereby displaying a tendency to investigate with a preconceived notion. The court was, however, mindful of the previous decisions regarding the chilling effect of the cost orders on the scale appealed against, but was of the view that the facts of this case warranted such an order. It is right that each case must be judged on its own facts, and that the admonition against the laissez-faire approach to such punitive cost orders ought not to put a steel armor against deserving persons where such orders are called for and are justifiable. Go down. Go down. And then it refers to the SARS judgment, which was the provincial judgment. Go down. No, the Constitutional Court judgment, sorry. Right? And then it says, the first respondent submits that there are other compelling reasons why the appeal should be heard, such as the interpretation of section 69, 79, and 9 of the Public Protector Act. There is a pending case between the President and the Public Protector before the Constitutional Court, in which section 79 will be considered. For each of section 69 and section 9, there are no less than 2 decisions of the full bench of this court which have made consistent findings of what these sections mean and how they operate. There is therefore no further clarification needed in that regard from the appellant courts, and no public interest will be served by an appeal in respect to which there is no legal uncertainty. Go down. In the circumstances, I am not persuaded that another court would come to a different conclusion, and then the full bench refuses application for leave to appeal. That is upheld by the SCA there, and then there's an application for leave to appeal to the Constitutional Court. Shep will just go to 8.1 in the bundle. So we know that the leave to appeal was 2 judges of the SCA, Wallace and Mothe, in September 2001 refused leave to appeal. Leave was reconsideration was then sought by the Judge President Meyer on 28th January 2022, who then refused such reconsideration, and then they go to the Constitutional Court. And in paragraph 36 of the application, it says that it is, in my view, there's a word missing of the above. It is in view of the above that I submitted the conclusion, actually, with respect that I'm constitutionally mandated to conduct investigations when I'm confronted with a complaint, including a complaint that exceeds the prescribed 2-year period in order to establish the presence of exceptional circumstances. So the Public Protector tells the Constitutional Court that she must investigate in order to establish the presence of exceptional circumstances. In paragraphs 39 to 45, she deals with the unlawful establishment of the so-called rogue unit. Says that it is common cause that the unit was established within SARS during Mr. Godin's tenure as SARS Commissioner around February 2007. Despite the fact that neither the SARS Act nor the SARS Amendment Act refers to objectives of SARS as a covert gathering of information or establishment of an intelligence unit. And then there's a jump that says that it is in view of the above that Mr. Godin and SARS correctly deemed it necessary to conclude an MOU with the NIA and to request that the then Minister of Finance provides funds specifically for a unit which would be operated by the NIA because SARS did not have a legislative mandate. And then they rely on this memorandum that demonstrates that at the time of establishing the unit, Mr. Godin was cognizant of the fact that SARS did not have a legislative mandate for the establishment of the aforesaid unit within SARS and therefore required the cooperation of the NIA. Reliance is then placed on Section 205 of the Constitution. Go down again. And then they deal with the memorandum concluded between NIA and SARS was because of a statutory limitation. And she then says to the knowledge, let me rather read 43 out before I misrepresent it. Sorry, let me do that. It is therefore apparent that the memorandum concluded between the NIA and SARS was because of the statutory limitations on SARS against establishing its own intelligence unit and capacity of the kind which was envisaged. It is in view of the above that I submit with respect that the Public Protector was justified in concluding the investigations which revealed that Mr. Godin established the aforesaid unit in spite of being well aware of the fact that SARS did not have the competency to carry out the intended intelligence gathering activities, which is plainly unlawful. To the knowledge of the respondents, the remedial action I issued was duly implemented to the extent that the intelligence agency and SARS arranged for the delivery of equipment used by the so-called rogue unit back to SASA with the participation of the Public Protector. And this committee received a letter from Commissioner Kieswetter in respect of that equipment, which the committee would be familiar with the contents. I therefore submit that with respect the court are co-erred in making a finding to the effect that no intelligence unit was established by Minister Godin at SARS during his term as SARS Commissioner. They deal in paras 46 to 48. Public Protector says that none of these reports, except for the OIGI report, have been set aside by a court of law. The OIGI report was only set aside long after the Public Protector had published the report, which is the subject matter of this case, and even then the merits thereof were not considered during the setting aside of the same. Go down. It is therefore apparent that the memorandum concluded between the NIA and SARS was because of the statutory limitations on SARS against establishing its own intelligence unit and capacity of the kind which was envisaged. It is in view of the above that I submit with respect that the Public Protector was justified in concluding the investigation which revealed that Mr. Godin established the aforesaid unit in spite of being well aware of the fact that SARS did not have a legislative mandate for the establishment of the aforesaid unit in SARS and therefore required the cooperation of the NIA. Reliance is then placed on Section 205 of the Constitution. It is therefore perfectly reasonable and rational for the public protector, having conducted their own independent investigation, to also rely on these reports in the circumstances. So the court erred in finding that the public protector took consideration of irrelevant considerations and relied on discredited reports. So that's what the court said. What you don't find and what you may want to ask the public protector when she comes and gives evidence is, where on appeal did she allege to the appeal courts that the High Court erred in any factual finding which it had made in its judgment, as has been raised before this committee. Chair, I want to take you to two further documents. If you look at, Shepherd, pull up the document called Comparison. On the stick. It's called Comparison Table.
Can we use that and take 10 minutes break whilst you're checking that? Okay, we'll take 10 minutes to break. Thank you.
Recording stopped.
And what I'm going to do is the second column deals with the KPMG report, and the first column is what is in the PP's report. So I'm going to ask Shepard to put up on the screen the PP's report, and I'm going to read from the KPMG report, and the members could then see what the similarities are between the two. So if Shepard goes to paragraph 5 to 11 of the PP's report. And I will have on my screen document that we've just shown you, and I'll read from there. So this is 5.2.11 of the SARS report, the PP's report, and I'm reading from PDF page 9, or it's got the case lines reference to it, so I'm going to use it at page 892. KPMG report says, for various reasons, the intended mechanism and the relationship did not materialize as intended, and SARS continued with developing its own capability caused by lack of trust and cooperation between the entities. I'm reading from the KPMG report. And so what you can see on the screen is a similar paragraph to what's in the KPMG report. Chair, would it be easier if I put the two up on the screen together so that that can be seen? Would that be an easier exercise? Because it seems a bit more difficult to do it that way.
That would be better.
And if I've misrepresented the paragraph in the PP's report, it could be easily. Put them up at the same time.
Okay, just as you are doing that, Honorable Heron, I see your hand.
Thank you, Chair. I just wanted to get clarity that the document that Advocate Bowers prepared with the two columns, that document has been shared with us or will be shared with us as well.
Good point, Advocate Bauer. Can you just quickly respond to that?
Chair, it will be shared.
Okay. Thank you. We will share that, Honorable Heron, with everybody.
In doing this exercise, it will also show you if my page references is correct, because this wasn't initially prepared. It was initially prepared for purposes of asking questions, etc.
Okay.
So I've done that.
Thank you.
Have you split screen and then shared it? Can you do it as a horizontal split shape? Then it won't reduce in size.
Class, take it to class.
As horizontal split it and then share. Okay, Chair, we can. We're not going to be able to do it in that way. So let's put up on the screen this PP's report. I will indicate clearly which paragraph is on the screen, and I will then read from the KPMG report.
It's okay. So I get that to be a difficulty here on the screen, but as you share the document, to everybody, will it be able to be done in that way?
Would you prefer me sharing the document that's got both versions on it?
Yes.
Okay, so put that version. Put that version.
I thought that's also what the member also wanted to check, if the availability of it.
So take the first one. In doing that, what just open the I just want to have it on. What page was it? 24. So in some cases, there's a similarity in wording, and in other cases, it's more exacting than that, but the sense is the same. Right? So the first paragraph we referred to was 5.211 of the report, and that fits under the heading, which we see in the report that says memorandum requesting funding of an intelligence unit, and it's in the section of the report that says SARS response, and it's summarized there. So the heading says, for various reasons, the intended, I'm going to read the KPMG report and the committee can follow the PP's report. For various reasons, the intended mechanism and the relationship did not materialize as intended, and SARS continued with developing its own capability caused by lack of trust and cooperation between the entities. Go down. Purpose of the submission, and we're now at 5.2.12. The purpose of the submission was to obtain approval from the Minister of Intelligence, which at the time was Mr. Ronnie Kasrils, for the establishment of a deep COVID capability, enabling the NIA and SARS to jointly embark on the COVID collection and surveillance of strategic priorities relating to border intelligence. The capability was to be staffed with highly trained specialists focusing on agreed priorities within the area of anti-smuggling, and would provide the ability for SARS and the NIA to carry out their respective mandates. It was stated that in order to have such a dedicated capability, there would be necessary to form a unit to be staffed with SARS personnel under the command and employment of the NIA. On the left column is the PP's report. On the right column, I'm reading from the KPMG report. So the next paragraph is 5.2.35.6. And that is under the heading that says KPMG report, right? And the KPMG report says each time when the name of the unit changed, it was marked by an event which resulted or possibly could have resulted in the damaging of especially the reputation of SARS. Pattern developed around the name change being it was either internally announced that the unit was disbanded or externally in those instances where the media was aware and individuals departed under suspicious circumstances with financial settlements, and the justification being in the interest of SARS, where after it continued functioning under different guise and name, right? So the next paragraph you'll see is also attributed to KPMG under that heading, and it says, the possibility exists that the interception Van Lochenberg referred to in his WhatsApp communication with Walters may also include third-party interceptions on his behalf. The same applies to the mystery of unexplained instances of emails appearing on his allocated laptop in which he was not a recipient. These email correspondence clearly belong to other parties. And then 5.5.5 was under the heading issues in dispute information regarding the recordings of Mr. Andries Petrus Jansen van Rensburg and Mr. van Rensburg, and it reads, in the KPMG version, the installation was allegedly instigated by Nel and Leesk, and the purpose was to provide the ability to Nel and Leesk to monitor activities and discussions occurring in certain offices and general office space in the DSO and NPA. The office and office space selected and identified at least included that of Nel, Leesk, Ngwingwa, Piccoli, and a boardroom where meetings took place. The concern was that information may or may not be disappearing from the offices, and SAPs were suspected as the culprits. Right, so that's a more general statement that comes out. Then if you go to 5.5.7, the equipment was installed in July 2007 and monitoring activities continued. The installation provided off-site access to the recordings for Nel and Leesk, and also Lombard, who claimed to have been responsible for the maintenance thereof. Then at 5.5.8 is the account of the phone call from Mr. Pillay soon after the installations were completed. It is alleged that Pillay requested Janssen van Rensburg to provide him with records and reports on the discussions that took place, and it is claimed that Nel and Leesk were allegedly not aware of the request. The request came as Pillay was aware that Lombard also had access to the recordings. Pillay allegedly indicated that the request was authorized at higher levels. Janssen van Rensburg claims that he believed the information was needed for the president. Recordings, there was a consistent primary of discussions about the Celebi and Aguiliotti investigations. So in 5.5.36, which falls under the category of conclusion, the unit was established by Pillay at the time when Goddan was Commissioner of SARS. Here, the KPMG report said we found no evidence that Goddan was informed about the existence of the unit. However, considering his position as accounting officer, it is reasonable to expect that he ought to have known of the existence of the unit. The phraseology in the PP's report is it is highly unfeasible that the unit's officials operated the unit in isolation of their principals. Right? And then we come to the Sikhakhane report. Just skip the first column. That's just the background to the Sikhakhane report. Right? Go down. Go down. All right. So if you go to Shepa, you must go to I'm going to have to read the Sikhakhane report to you, and then you go to 5.2.17 of the report. Mm, 258, I think. So you must go to 5.2.17. Just go down. Right. The Pillay introduced Mr. van Lachenburg to the Commissioner of SARS, Mr. Pravin Goddan. Right. Go down. The current Minister of Cooperative Government and Traditional Affairs. All right. Mr. van Lachenburg testified that Mr. Goddan told him that he sought to develop intelligence capacity in SARS within the context of tax and customs. And then the next paragraph would be 5.2.18, right? Which would be paragraph 43 of the Sikhakhane report. And it reads, there's a bit of a text, and the relevant part says, during this meeting, Mr. Pillay explained how SARS sought to increase its capacity to investigate organized crime and illicit trading, and the impact thereof on the tax and customs mandate of SARS. And then it's linked to the next paragraph. It says, during 2004-2005, SARS set up study groups to understand the illicit economy and how it functioned. SARS also began official interactions with the South African Police Service, Military Defence and NIA. It had previously done something similar with the National Prosecuting Authority, which resulted in the creation of special tax units. The plan was that the unit would be housed within NIA, which dealt specifically with SARS tax and customs intelligence related issues. The next one would be 5.2.19. So I'm going to, 5.2.20. In line with this plan, SARS, through its highest office, approved the creation of a group which was known by different names, including the Tiger Group, Special Projects Unit, the NRG, and later the High Risk Investigation Unit. As explained in greater detail below, the unit was staffed with members who came primarily from the intelligence structures with skills to conduct surveillance, investigate and monitor those involved in the illicit economy. That's 43.4 of the Sikhakhane report. The next one would be 43.45 and 43.5 and 6. And it would read, SARS, however, SARS therefore found itself in the position just let me double check. I don't make a mistake. I've already read part of it out. All right. Okay. 5.2.22. February 2007, the then Commissioner of SARS, Mr. Godana, addressed a memorandum to the then Minister of Finance, Mr. Trevor Manuel, seeking approval for funding of intelligence capability within NIA in support of SARS. Copy of the memorandum is attached. All right, and then it goes further, and it says it is clear. I think you must go down. All right, it is clear ex facie this memorandum that SARS sought to establish within the NIA a unit for the collection of tactical intelligence, which implies inter alia penetrating and intercepting organized criminal syndicates. And Chair, those are some of the paragraphs that I want to draw to your attention, and we will deal with some of it in further argument, but those are the correlations. I'm going to put those paragraphs into the columns that isn't there, and then forward it on to Shepherd to forward that on. Yeah, Chair, that takes me to, we can either deal with the judgment part of the IGI. I mean, Chair's hands if you want to settle 5, and we can deal with the judgment part of it.
we'll push, let's assess at past how much you can
Because I
do by
want
then.
I want to finish it in one go, and that's why I'm asking whether I should do it. But maybe I should just start.
Let's
Okay,
see
let's see.
how you go.
Chip will go to the judgment at paragraph 112. And this is the third report relied upon by the Public Protector, which is the report which originated from the Office of the IGI of Intelligence. It is the report that was issued on 31 October 2014. And it is in respect of this report that the Public Protector had stated in her report at paragraph 5.2.26, which you'll see from the repeated, that she was reliably informed. The quote comes from 5.2.26 of the report, that it was in the custody of the former Minister of State Security, Mr. Pillay Duba, from whom she tried to get a classified copy of the report without success. She also states that she had requested the President's assistance in making available the declassified report by the Minister of State Security. And here, the Public Protector relies on this report despite explicitly stating that she had not seen the report. This was the issue that Advocate Mpofu had canvassed at great length with the Public Protector, and we will deal with it in questions. But I just want to take you through the argument and the judgment. She relies on it because she has it on good authority that it was found in that report. And what she has on good authority that it was found in that report was that the SARS had created a COVID unit utilizing COVID and intrusive methods, which was not in line with the SARS mandate and in violation of Section 209 of the Constitution, which empowers only the President to establish any intelligence service, and that the establishment of an intelligence capacity within SARS, a capability exclusive only to legislated intelligence service, was illegal. Now we know now that that's a direct, comes directly from the IGI report. Paragraph 14, it says the Public Protector further recites the remedial action proposed by the OIGI in its report, namely that criminal charges be investigated against Mr. Gordhan, Mr. Pillay, Mr. Van Lachenberg. So he is an implicated party because the remedy is there, and a certain Mr. Richa for the establishment and involvement in the intelligence unit in SARS. You will recall that the argument was he only became relevant in the second half of the charges, that in the second half of the complaint that was going to be the subject matter of another report. In paragraph 15115, right? Despite the fact that the Public Protector, according to the report, has never seen or verified the contents and findings of the OGI report, she ordered the Minister of State Security to implement within 90 days of the issuing of the report and acting in line with the Intelligence Services Amendment Act, the OIGI report dated 31 October 2014 in its totality. Right? And the Minister of State Security was further ordered to ensure within 30 days that all intelligence equipment utilized by the unit is returned, audited, and placed into custody of the State Security Agency. Finally, the Minister of State Security was ordered to, within 14 days of the issuing of the report, to avail a declassified copy of the OIG report to the officers of the Public Protector. This is the remedial action in 8.3.1 to 8.3.3 of the report. The court then says the Public Protector further makes her findings in respect of the OIG report ostensibly in terms of the powers vested in her by Section 181, 2 and 3 of the Constitution. It is difficult to understand on what basis these sections of the Constitution can notionally grant the Public Protector the power to rely on a report that she herself has not seen, because this is what she says in the report. Although the Public Protector undoubtedly has wide investigative powers, it does not follow that she can blindly rely on evidence and facts that she's unable to verify independently, but only became aware of on good authority. As was said by the Supreme Court of Appeal in Public Protector v. Mail and Guardian, the public protector must not only discover the truth, but must also inspire confidence of the truth. So the committee is very familiar with this paragraph. So I'm not going to read out of the whole paragraph. So let's go to 117. Had the public protector, however, applied a mind to the OIG report before and not relied on good authority, she would have appreciated the shortcomings of the OIG report. And in turn would not have issued the impugned remedial action. Had she applied the mind, she would have realized two important aspects. The Inspector General acted ultra vires in investigating SARS officials and activities, and Mr. Pillay and Mr. Godan were not afforded a hearing as the audi alteram partem principle was not adhered to before coming to her findings. Now, we know, Chair, that apart from the affidavits before court, there were also heads of argument and oral submissions before the court. Now, I can't put before the committee what oral submissions were made other than what is recorded in the judgment, which we're going to come to in a moment. But I just want to take you, there were 3 sets of heads of argument filed in this matter. And they are, Shepo, if you go to bundle E7, 10 at right, go to page 10. Use the PDF versions. Right? So what I'm taking you to is reflected in the second supplementary heads of argument. So maybe just go to the bookmark so that the committee can see. The PP's heads of argument is the first supplementary set, and there's a second supplementary set. So what we're in now is actually the under the heading. Let's just see where paragraph 37. Go down. Go down. Sorry, now go to click on the second supplementary heads and go to paragraph 37. And it says there that the 5th respondent misapprehends the powers of the public protector by suggesting that there was anything wrong with how she obtained the IGI report. In fact, as demonstrated by the EFF, the IGI report was sufficiently alarming to the general public for its uncontested contents of the existence of the SARS unit with intelligence gathering powers that it utilized to bug the NPA and DSO. The public protector, on good authority, became aware of the IGI report, which was left at the offices by unknown persons. When the report came to her attention, she took steps to ensure that she could lawfully utilize it for investigation. She sought the declassification of the IGI report. The minister was not cooperative on that score, erecting unnecessary obstructions to the performance of her duties, in contravention of the constitutional duty in section 181, 2, 3 of the Constitution. The submission that the public protector failed to uphold the Constitution by not disclosing the source of her access to the IGI report is a deeply flawed criticism that belies the true constitutional position. All right. Now, That was the argument before the court in that regard on the IGI report. Go back to the judgment. Right. Paragraph 118, most alarmingly, however, and despite the fact that the public protector stated in the report that she did not have sight of the OIG report before coming to her findings, counsel, acting on behalf of the public protector, asserts in the third set of heads of argument that this investigation yes, the public protector made an independent assessment of the legal and factual questions involved in the investigation on the SARS intelligence unit and made their own conclusions. The investigation included assessing the OIG report for its factual and legal conclusions. Having carefully studied the OIG report, conducted her own independent investigation on the issues covered in that report, she concluded that the findings and recommendations in the OIG report be implemented. In other words, she did an investigation of Pillay van Lochenberg done and concluded that the findings and recommendations in the OIG report that they be criminal, that they be recommended that they be criminal action taken against them. We not phrase it wrongly. That criminal charges be investigated against them. Right? When she issued the remedial action on the OIG report, she was satisfied that the OIG had acted within its powers in conducting the investigation and was correct in its factual and legal conclusions. And then that was in the third set of heads of argument. Then it said during argument, go back to the judgment, when counsel for the public protector was confronted with the contradictory statements in the heads of argument, the debate regarding the OIGI report took a bizarre turn. Counsel on behalf of the public protector now conceded that despite the explicit statement in the report that she had not had sight of the OIG report in preparing the report, she had in fact had the OIG report in her possession when she drafted the report. The public protector now claims that she subsequently received the OIG report from an anonymous source who left it at her offices. And if you go, we know that the public protector had the OIG report from early January. And so if you go to the heads of argument, just go to the heads of argument again. You see in paragraph 7 of the first sets of heads of argument. Just click on your bookmark and you go up. No, down the 26 June one. And you go to paragraph 7. We'll see that the public protector says go down. The public protector started engaging with the SARS Acting Commissioner Mark Kingan by addressing a comprehensive inquiry dated 3 December 2018. And right, she addressed further inquiries to the Office of the Inspector General in a letter dated 14 January 2019. Right, and when that letter went off, she had already had the OIG report. The Office of the Inspector General immediately responded in a letter dated 15 January 2019. confirming having conducted an investigation into media allegations against the Special Operations Unit, SOU, and or other branches of the State Security Agency in 2014. The Inspector General also confirmed the existence of a report on the investigation by declining to give it to the Public Protector. As a consequence of the Inspector General's position on the Public Protector issued a subpoena on 18 January 2019 against the Minister of State Security for the production of the report. In fact, it was issued against both the Minister and the IGI. The Inspector General subsequently undertook to submit the report to the Public Protector after consultation with the Minister of State Security. The Public Protector subsequently received the report of the Inspector General of Intelligence through an anonymous source who left it at the offices. The chronology in the heads are not entirely accurate, given that the report had been obtained with its classification of top secret. There was a dispute over whether she could lawfully rely on it. The applicant makes a meal of this in his complaint against the Public Protector, although this must be water under the bridge. The Minister of Safety and Security subsequently agreed to give the Public Protector a declassified version of the IGI report with redactions of sensitive information on it. There was some disagreement on the scope of the redactions, with the consequence that the State Security Minister launched legal proceedings against the disclosure of the IGI report. At the time of drafting these submissions, there were two irreconcilable positions that had occurred. Paragraph 8, it says, while awaiting judgment on whether the IGI report could lawfully be declassified and published, the Minister conceded an application to review and set aside the classified IGI report, whose disclosure she had contested in court and for which a judgment was outstanding. These events do not necessarily impact on the review application. And this is an important part, Chair, because it's an important legal principle that is absolutely correct. And I don't think it will be in dispute, but it's an important legal principle because it underscores the CR17 matter and the Gurdan matter. These events do not necessarily impact on the review application, which must be decided on the basis of information that was before the Public Protector and in the review record. And it has relevance for when we argue as to how that impacts on the minority judgments when the erstwhile Chief Justice Mkhwebane decides to consider the appeal from a review with reference to information that arises after the decision and not based on what was before the Public Protector at the time. All right. So I'm just pointing that out, that appears to be a common cause legal principle adopted. This means that the fact that the Minister has conceded an application by Mr. Lochenberg to review and set aside the IGI report does not bar this court from evaluating the merits of the review application on the basis of all the information that was before the Public Protector, including the IGI report. To the extent necessary, the status of the IGI report in these review proceedings will be addressed in supplementary heads of argument, depending on the position of the applicants to its relevance to evaluating the validity of the Public Protector's report. And then let's go back to the judgment. So we know that the Public Protector had claimed that she subsequently received the OIG report from an anonymous source who left it at offices. This turn of events is disturbing to say the least, and it is difficult to label the Public Protector's conduct in this regard as anything else but dishonest. In her heads of argument, the Public Protector criticized Mr. Gurdan for making a meal of this in his complaint against the Public Protector, and that it was water under the bridge, as the Minister of State Security subsequently agreed to give the Public Protector a declassified version of the OIG report with redactions of sensitive information on it. The argument, unfortunately, does not cure the blatantly misleading statement made by the Public Protector in the report. Comments made by the court in SARB versus Public Protector and others cannot be emphasized. And then it quotes a paragraph that we will come to in the SARS judgment when we deal with the CX matter. Go down. won't necessarily go there. Maybe we should. However, there is no getting away from the fact that the public protector is the constitutionally appointed custodian of legality and due process in the public administration. She risks the charge of hypocrisy and incompetence if she does not hold herself to an equal or higher standard than that to which she holds other subjects, those subject to her writ. A dismissive and procedurally unfair approach by the public protector to important matters placed before her by prominent role players in the affairs of state will tarnish her reputation and damage the legitimacy of the office. She would do well to reflect more deeply on the conduct of this investigation and the criticism of her by the Governor of the Reserve Bank and the Speaker of Parliament. Statements such as this made by the public protector in an answering affidavit and heads of argument only serve to tarnish her reputation and damage the legitimacy of the office that she holds. Those who are and have been the subject of an investigation by the public protector, as well as the public at large, must have faith in the integrity of the office of the public protector and its incumbent. After all, the public protector is regarded as one of the most invaluable gifts to our nation in the fight against corruption, unlawful enrichment, prejudice and impropriety, state affairs and for the betterment of good governance. And then it goes to dealing with Mr. van Lachenberg having setting aside the report, and it says any reliance thereon is apart from the fact that the public protector's reliance thereon has in any event been highly irregular, now moot, as the IOGI report is incapable of being implemented. Counsel on behalf of the public protector in the last desperate attempt submitted that the reliance on the OIGI report cannot be criticized, as the OIGI report had not been reviewed at the time. Our own ambivalence regarding the OIG report discussed above totally discredits our own report. There is no merit to the submission. To add insult to injury, the public protector's failure to add insult to injury, the public protector never provided the OIG report to Minister Kudan and Mr. Pillay to respond to during the public protector's investigation. The procedural unfairness of the process that led to the report is dealt with more fully elsewhere in the judgment. But probably the most egregious is the public protector's failure to consider the extensive body of evidence that Mr. Pillay provided to the public protector. And then he goes on to that. And I just want to take you to one further reference in the heads just to complete it. If you go to PDF page 140, and I'll go to the heads, the bundle E document over there. Yeah. Yeah. Right. You will see go down to paragraph 31. Then go up. Actually, go to 30, it will make more sense. Minister of Safety and Security had recently filed an affidavit when she alleges that the public protector's remedial action against her are incompetent in law for the simple reason that they are incapable of being implemented. The erstwhile IG acted ultra vires. She further alleges that the IGI report had been set aside by a court of law in an application that was launched by Mr. van Lachenberg. The IGI report was set aside by way of a consent order between the parties in proceedings with the public protector to the knowledge of the minister as a direct and substantial interest in the matter was not joined as a necessary party. The consent order had the effect of rendering the remedial action of the public protector moot and unimplementable in circumstances where it has not been set aside in proceedings where the public protector was involved. So in the heads of argument, it is conceded that the order rendered the remedial action moot and unimplementable. The public protector, in the next paragraph, it states he is considering launching an application to have the order setting aside the IGI report set aside, and in the event that she does so, will seek postponement of this application. That never happened, Chair. And then just go to paragraph 38. 37, sorry. Nope, it's 38. But I think we've dealt with it already. Yeah. Okay, so those are the submissions on that aspect of dealing with at least 3 or 4 of the aspects that deals with bias in the judgment of that. There are 1 or 2 aspects that we want to deal with in relation to the equipment, and 1 other aspect, if this is a convenient time for us to adjourn, because I'm not quite ready with the put it up on the screen. It's like a last lesson on a Friday afternoon, during Ramadan. I'm reminded.
Well, whatever I was going to say, once you mentioned that, I respect that you have this energy, so I will not go beyond that. You've just pushed me back and said that. Thank you, Advocate Bauer. Yes, it's a Friday, just towards 5. But I think we have to be grateful to the members for their commitment to stay on their work, regardless of circumstances and the days. It therefore does look like we'll pause there for the day. Perhaps also to indicate to members the approach now is that we, and hopefully we'll be able to do that, Advocate Bauer, that we can resume to kind of try and finish up and complete this. I would prefer we do that in a day and a half. We're done with it. I think that resuming therefore, so that we allow members to be able to do other things on Monday is the end of their constituency week, which they have not necessarily been effectively doing because of the work that we've been doing. Well, maybe we should resume on Tuesday and finish up on that. And as part of that, members, just to indicate that we working very hard for the finality of the decision to get us closer to the resumption of the inquiry. Maybe we can also use that Tuesday to indicate where we are at that point. If we're not able to announce the finality, then we'll indicate a process towards that. But as you leave, I think it's important that you start putting this in your mind as part of budgeting your time, because we would not be issuing a revised program pending us finalizing that. So Thembinkosi is not able to do that because we have to make sure that when we send that out, it is the kind of program that takes us to the end. And it's a realistic program in terms of it not having any other off-ramps, but also to take into account in your planning, even though we'll put that firmly in detail when we do so, you know that we have at this stage 4 days left for completing that testimony with the legal team of the PP. We would have another 6 or so days with the evidence leaders. We would have about a day or so, 2 days or 3 days for the members, depending on how much time members would need, and a day or so for the re-examination, issues of closing arguments that would need to be there, which can take us to about 3 days or so. And then we're also factoring that into allowing some time for the written arguments. Anything between 6 to 10 days to do that. You are aware that there's always a standing item of the Audi that will provide once we have a draft report of about 10 days at this stage. I'm just giving you a sense that when we come back, when we resume, when we get to that finality, the program will take those things into account towards the conclusion. But I don't want now for us to get to that point. We're working very hard, even if it means at some point pushing those role players and assisting them here and there and so on. But I'm very confident that in the manner we are pushing, we will get to the point that we need to get to with our work that you so diligently did. So on that, colleagues,